Good morning, everybody. I believe this is the February meeting of the Oregon Liquor Control Commission. Would you please take the roll?
Commissioner Curran?
Here.
Commissioner Floyd?
Here.
Commissioner Harper?
Here.
Commissioner Miletus?
Here.
Commissioner Posick?
Here.
Commissioner Raval?
Here.
Chair Rosenbaum?
Here. Welcome, everybody. The first item on the agenda is the contested case hearing. Presentation of oral argument on exceptions to the proposed order issued by the Office of Administrative Hearings. Arguments are going to be presented by staff, licensees, permittees, and applicants on Taylor Bar and Grill. Let's get started. Good morning.
Good morning, Chair Rosenbaum, Commissioners. I'm Andy Chiller with AP&P. Next to me is Mike Mills, attorney for licensee, and next to him is licensee Ramsey Hattar, sole member of Zidane Outdoor LLC, the licensee for Taylor's Bar and Grill. We're here to address the proposed final order in the contested case proceeding regarding Taylor's Bar and Grill in Eugene, Oregon, in which the administrative law judge recommended that licensee's full on-premises sales license be canceled based on a history of serious and persistent problems. Commission staff did not file comments to the proposed order we're discussing today, so I will mostly limit my comments to giving an overview of the allegations, the proceedings, and the proposed findings, and allow Mr. Mills to present his client's exceptions, after which I would ask for the opportunity to respond. By way of overview and background, in August 2018, Commission staff issued a notice of proposed license cancellation to Zidane Outdoors LLC, the licensed entity, and Mr. Ramsey Hattar as the sole member of that LLC, alleging that there was a history of serious and persistent problems at the licensed premises. The notice charged that between approximately June 2017 and June 2018, there were 29 incidents that occurred at the premises or in the immediate vicinity, many of which involved violence, fighting, excessive intoxication, and some of which resulted in serious injury to patrons of the premises. The notice also charged one violation for permitting disorder for an incident involving a bartender physically escorting a patron from the premises to a location across the street, punching him in the face with a closed fist, and knocking him unconscious. Licensee requested a hearing on the charges, which was set for the first week of June 2019 in front of Senior Administrative Law Judge Dov Gutman. Commission staff subsequently amended the notice 3 more times to add additional incidents that had occurred. Between the time that the Commission staff issued the original notice in August 2018 and March 2019, when the investigation into potential incidents at the premises ceased in anticipation of the hearing, staff ultimately added 13 more incidents, bringing the grand total of alleged incidents to 42. Many of these newly added incidents also involve violence and injury, including a fatal DUI, a fight resulting in a patron getting hit so hard he suffered an open jaw fracture that required surgery and having his jaw wired shut, 2 separate gun incidents, one involving a dispute that began when a patron groped another patron inside the premises and ended with a gun being pulled on him in an alley behind the premises, and another involving an individual entering the premises with a gun and brandishing it inside a crowded hallway inside the premises that was filled with patrons. The hearing commenced on June 3rd, 2019. On June 3rd, 2019. Right. It lasted a total of 7 days, 2 more than originally scheduled. The 2 additional days of testimony took place on July 2nd and 3rd, 2019. In all, 33 witnesses testified at the hearing, 29 of them on behalf of the Commission. The Commission and the licensee were given the opportunity to submit written closing and arguments in a reply, and the evidentiary record closed on September 11th, 2019. Judge Gutman issued her proposed order recommending cancellation on January 3rd, 2020. In her proposed order, Judge Gutman found that the Commission satisfied its burden, showing that there was a history of serious and persistent problems at the licensed premises. Specifically, she found that the Commission satisfied its burden of proof for 36 of the 42 incidents alleged. Specifically, she found 21 proven serious incidents, which under the relevant statute and final order precedent includes incidents involving lewd or unlawful behavior, violence, the threat of violence, fights, or harassment. 2 proven incidents involving public drunkenness, both of which involve female patrons intoxicated to the point of not being able to stand up or walk without assistance, and 1 culminating in the 2 patrons falling down the stairs in their home and sustaining significant injuries. She also found 6 proven incidents of patrons committing the offense of driving under the influence of intoxicants, including 1 involving a fatal crash where a former University of Oregon football player was thrown from the car and killed. She also found 7 incidents involving theft or property crime. Judge Gutman also concluded that licensee failed to satisfy its burden of showing that it had the willingness and ability to control the premises. As you're aware, if there's a finding that there is a history of serious and persistent problems at a licensed premises, the licensee has the opportunity to demonstrate that it has the willingness and ability to control the premises as an affirmative defense in order to mitigate against the standard sanction of license cancellation. In coming to this conclusion, Judge Gutman looked at both the time period prior to the time that the commission staff held an intervention meeting with licensee Hatar and the manager of the premises on June 7, 2018, to discuss the problems that were occurring and the time period following the intervention meeting. In the year prior to the intervention meeting, she found that of the 24 proven incidents that had occurred in that time frame, 16 were considered serious, which averages out to a little over 1 serious incident per month. She also noted that 13 of those 24 incidents occurred at the premises, involved an employee of the premises, or was reported to an employee of the premises, meaning that licensee either knew or should have known that those incidents occurred. She found, however, that there was no evidence in the record of licensee taking any steps whatsoever to address the problems at the premises during that time frame. Following the intervention meeting, licensee claimed to have made changes to the business aimed at better controlling the premises and reducing the number of incidents. In looking at that 9-month time period following the intervention meeting, there were 12 proven incidents, 11 of which were serious, which again averages out to slightly more than 1 serious incident per month. Citing the well-established principle that there cannot be a finding of willingness and ability to control the premises without an actual and substantial reduction in the number of incidents, and noting that there had not been a reduction in the number of incidents at all, let alone a substantial reduction, Judge Gutman came to the only conclusion that she could under the facts of the case and the governing final order precedent, that licensee here did not demonstrate a willingness and ability to control the premises. Judge Gutman also found that the commission satisfied its burden on the permitting disorder charge. As noted at the outset, commission staff did not file comments, but licensee did file exceptions to the proposed final order. In those exceptions, licensee appears to concede that the number of proven incidents constitute a history of serious and persistent problems and does not appear to refute the finding on the permitting disorder charge. Other than objecting to the classification of 3 of the proven incidents as serious and the inclusion of one of the DUIs as an incident, the majority of licensees' objections seem to focus on the finding of a lack of willingness and ability to control the premises. Before I turn it over to Mr. Mills, I would just like to ask the commissioners to keep a few things in mind as they listen to the remainder of the arguments. In their exceptions, licensee discusses the supposed reduction of certain types of incidents at the premises, addresses at length the steps that licensee claimed to have taken to address the incidents that were occurring, and outlines several purported facts that they claim the ALJ gave insufficient weight to in coming to her conclusion that licensee did not demonstrate a willingness and ability to control the premises. I would ask the commissioners to not let these arguments cloud the ultimate issue or overshadow what is a straightforward and well-established principle of our history of serious and persistent problem precedent, that without a reduction in the number of incidents, regardless of licensee's attempts or intentions, there cannot be a finding of willingness and ability to control the premises. I think it would be helpful to quote directly from a prior commission decision on this, that's exactly on this point. In Big Shots Bar and Broiler, decided by this commission in April 2010, the commission held, quote, in cases in which the commission found that the licensee had demonstrated a willingness and ability to control the premises, the licensee made significant changes in operations and or implemented new policies that effectively reduced the number of serious problems at the premises. On the other hand, where serious problems persistently recur even after the licensee takes measures to control the premises, the commission has held that the licensee did not demonstrate both the willingness and the ability to adequately control the premises. More recently, in Sting Pub, decided by this commission in June 2018, The commission stated, quote, efforts have not been enough, end quote, when serious incidents continued at the premises. The evidence presented in this case showed that at the outset of the investigation into Taylor's Bar and Grill, there was an average of one serious incident per month occurring at the premises. And at the end of the investigation, there was still an average of one serious incident per month at the premises. And in fact, if we just look at the time period since the intervention meeting, which licensee claims to have first received notice of the problems occurring at the premises, and when they began their efforts to control the premises, there have been enough incidents just in that time frame to support an independent finding of a history of serious and persistent problems. In the 9 months since that intervention meeting, there were 12 proven incidents, 11 of which were serious. This commission has previously found a history of serious and persistent problems in the matter of the Headless Horseman when there were 7 incidents in 13 months. In Balzer's Pub and Grill, this commission found a history when there were 5 serious incidents in 6 months. And in New Copper Penny, there were 8 serious incidents in 7 months and a finding of a history of serious and persistent problems. Finding a willingness and ability to control the premises under the circumstances presented in the current case would be a serious departure from the commission's prior precedent, and we request that the commission decline to do so.
Counselor.
Chair Rosenbaum and members of the commission, and Director Marks, you're not here, but Executive Assistant Paul. You know me, my name's Michael Mills. I've given you my resume in a previous case, and it's about the same, it's just a little longer, so. I'm here, and this is Mr. Ramsey Hattar. I'm here to tell you about the exceptions that I filed, and I disagree with Ms. Chiller on a number of issues, of course, but I agree with the findings of fact and conclusions of law that the administrative law judge set forth in her proposed order. And I'm going to show you that those findings alone are enough to give you a reasonable reason to find something less than cancellation in this, something like a fine and a suspension, which has been previously done when there's been a history of serious and persistent problems. We're not stating that a case was not made out, that it was a history of serious and persistent problems. And the administrative law judge indicated under numerous findings that Mr. Ramsey has the willingness to control. The only issue that I want to talk about today, and that I'll show you through her findings, is that he actually does have the ability to control the premises, and he has shown that. But before I begin my presentation on behalf of Mr. Ramsey, if you indulge me, Chair, I was saddened last week to read about the passing of Alan Scott, who was an administrative law judge for the OLCC, worked for the agency, I think, when administrative law judges or the judges, hearings officers, were still part of the OLCC. He was a year behind me at Willamette Law School, and we each went our separate ways, of course, but I made his acquaintance later after he came to the OLCC. There's probably not many people here who remember Mr. Scott, but I remember him fondly from years of working with the employees. He was talented and dedicated, much like the people that you have here today, up until the present time. But I wanted to take this opportunity to acknowledge Mr. Scott, which was truly one of the best ones I've seen. I have one other request, if it's within your power to do so, and that's if you please would not let Dan Croy retire before I do. He's been an institutional history guy, and I've known him for years, and he's helped me through many kind of an arcane look at the rules and regulations. This is the only chance. The reading of the exceptions and this is the only chance that Mr. Hattar and I have to ask you, request that you do something less than cancellation. I urge you, if you have not already had the opportunity, to read the exceptions, that you do so, because I disagree with some of the conclusions that Ms. Chiller has reached about what those exceptions show. And I ask you to do that. I don't have time here in the limited time we have to go over all of that, but I'm going to hit the high points and hope that before you make your decision, you read the exceptions, because it goes into detail. And I believe, of course I'm the author, but I believe that it makes a compelling case for something less than cancellation. First of all, the administrative law judge did not give sufficient weight to show that he has the ability. There were 4 allegations of drugging of co-eds that were made that supposedly happened inside the premises after Mr. Hattar took over. She found that none of those druggings were proven by the OLCC. She also indicated that there were a number of things that he put into play about the possibility of druggings, because he had been approached by Michael Bloom, the regional supervisor of the OLCC in the Eugene area, in October of 2017 about the possibility of druggings. And here are some of the things that he did. Prior to his ownership, he was aware that there'd been one incidence of drugging at the premises, and that a sexual assault had resulted as a result of that. This was under the previous ownership, not his, and Mr. Bloom made him aware of that early on. The following is quoting from the findings by the administrative law judge. Another measure instituted by licensee was the hiring of more DPSST trained employees to monitor the inside of the premises more closely. This is also a quote that she found from the facts. Taylor security staff is DPSST certified. They are trained to look for, among other things, fake ID, ID misrepresentation, visibly intoxicated persons, open containers, pictures in conversation, gang signage and clothing, unattended drinks, theft, inappropriate behavior and interactions, and confrontations. On busy nights, 2 security staff check ID at the front door. One security staff monitors the line of people waiting to get inside. 1 security staff monitors the fenced patio area and works the back hallway. Taylor security staff members use walkie-talkies to communicate and receive real-time alerts from other bars in the area. At closing, security staff members patrol inside and outside the premises as a preventative measure and provide assistance to patrons as needed. This is what she found he did before the hearing in order to address some of the problems that were occurring. He posted signs in the women's restroom that provides code words that women can use to get out of uncomfortable situations with the assistance of staff. He posted signage in the men's restroom about not driving while under the influence of intoxicating liquors. He implemented the policy that tailors clear all unattended drinks as quickly and as efficiently as possible, and he posted signs to not have the patrons leave their drinks unattended. These things were done in June of 2018, and in the exceptions, I've shown the administrative law judge has shown in her proposed order when these things were instituted, so you can follow the timeline. Mr. Hattar, I'm quoting it still, Mr. Hattar implemented the requirement that security staff check on VIPs that are leaving with 1 or 2 more males, including asking if they know the people who they are with, and offering to get a Uber ride for them. He purchased an ID scanning device for security to use at the front entrance to scan for fake ID. Mr. Foley, the inspector who did most of the legwork on this, has observed, and this is her finding also, Mr. Foley has observed Taylor's security staff doing a good job checking and spotting fake ID. Mr. Whiteside, another OLCC inspector, also testified that he has observed Taylor's security staff doing a good job checking and spotting fake ID. One of the emphasis that Mr. Bloom had when he talked to Mr. Hattar early on was that, I think his words, they're naive college girls come to college and use fake ID, and they get into situations that they shouldn't be in or that they didn't anticipate. Hundreds of IDs have been confiscated since Mr. Hattar took over, and the OLCC even assists sometimes and watches, and those IDs are turned over to the OLCC, and the OLCC decides whether they want to prosecute the minor or not for attempting to use ID or prosecute for using fake ID. Another thing that I believe the exceptions show, the administrative law judge did not give sufficient weight to the fact that Mr. Hattar has demonstrated the ability to eliminate contact by non-DPSST employees that result in physical harm to patrons. One of the most egregious things that happened before the meeting that we'll talk about was a bartender assaulted a patron who tried to take some alcohol from the premises and seriously injured him. And after that incident, Mr. Hattar instituted a policy, and this is a finding by the administrative law judge. Mr. Hattar implemented the requirement that regular employees, i.e. bartenders, not engage in physical interactions with patrons except in an emergency. Those are all handled by DPSST, which are state certified. I think you probably have been all familiar with what they do and how they are trained and what the administrative law judge found in this case, how they were trained and how they looked for things at Taylor's. He also implemented the requirement that Taylor's wear distinct and identifiable uniforms, and I submit to you that the record in this case and her findings indicates that the last incident involving a patron by a non-DPSST person was June 2nd of 2018. Now, that doesn't mean that DPSST employees did not control the behavior of unruly patrons by asking them to leave, and if they don't leave, making them leave, basically. And that's what DPSST persons are trained to do, is to not escalate the situation, but to make them leave voluntarily if possible.
Mr. Mills,
I'm
may
sorry.
I ask you a question?
Yes, you may. You speak up.
Now that you're saying that, when I was reading the exceptions,
Let me turn off my hearing aid.
when I was reading the exceptions, I saw that Mr. Hattar had implemented the requirement that the employees are not to engage in physical interactions. To me, that's a no-brainer that a bartender should not have to implement that. It's concerning to me that he would have to implement a policy not to have physical. It's against the law to assault anybody at any point.
I agree, and there were.
So how is this different? Implementing a policy.
Sure. There were DPSST persons at the site when the bartender did what he did, and he did so, and it's not an excuse at all. He did so because the patron tried to take a bottle of alcohol from behind the bar. He followed him out, and there were words exchanged, and he decked him. That shouldn't happen. The DPSS people should have been able to do that, but they basically got no warning. The bartender just did it. And the written instruction after that was meant to clear up that kind of a situation that doesn't happen again.
And so I guess I'm confused at how saying that there's a policy. I think it's a really fancy way of saying, don't hit the patrons. But it seems like to me that it didn't really change anything. That should have already been understood by the...
It should have been understood, and perhaps it was, because DPSST people had been doing that kind of thing. But in the heat of the moment, the bartender just didn't think, acted out, went against policy, did what he shouldn't have do, and the reiteration of the policy was what Mr. Hattar felt was necessary because that happened, and it shouldn't have happened.
Thank you.
Mr. Mills.
Yeah.
Mr. Mills. Me.
Oh, hi.
Hi.
Rick.
One of the things, not to interrupt your presentation, that you're on a roll, and I've turned up my hearing aids as well,
Yeah.
is I can't speak for the other commissioners, but I have read all of the exceptions.
Thank you.
So my question is, are you going
We've
to
all read all the exceptions.
are you going to continue to read the exceptions to us? Because it doesn't seem like these are the high points. These are the exceptions that we've all read. So not to tell you how to do your presentation, but we have read.
Yeah, I was not aware. I don't know what goes on in that
We
room
read everything on that.
behind you. So if
I'm-
you've read the closing...
let me finish. Let me finish.
Oh, I'm sorry.
It's that it's kind of like we've all been through PowerPoints from hell, and they read everything on the PowerPoint. We've read them.
Okay. I appreciate that information.
So
I did not have that information, and I'm glad that you did. So
if you want to continue to read them all, great, but I want to let you know that we've read them.
Actually, the part I was going to read is abbreviated somewhat from the 53 pages that you read, thankfully.
280 pages that I've read.
Oh, you read the closing?
Everything.
Okay. We're good. I just will hit the high points.
We forgive you for assuming we haven't read it.
Yeah. Some of the high points are that he did eliminate DUII reports emanating from the premises. You read the findings from the ALJ that indicated what he had done, and after those signs were posted, after the bartenders were instructed, there were no more DUII reports emanating from the premises. And the last one that emanated from the premises was June 15th of 2018. That, I think, was the fatality. And I want to say with regards to that the person who was driving that car was observed by OLCC on security cameras being served every drink at Taylor's, and he said at the hearing that he did not observe any signs of visible intoxication before that person was served at Taylor's. An unfortunate and tragic result, but I want to emphasize the fact that he was not served, a visibly intoxicated person was not served according to the OLCC inspector who looked at the tapes. He eliminated thefts from the premises. The thefts are left serious, but the last theft report was May 18th of 2018. Those thefts comprise 20% of the total of the serious of the incidents that were set forth in the ALJ's CPO. Also about the behavior of the patrons in the immediate vicinity, you read all of the things that he did to control the people in the immediate vicinity, and I have to say that that is the most problem that he had, is what happened when his patrons and the patrons from the other bars get into that funnel effect, and when outside agitators or people come in and start fights. You can see her findings with regards to what happened. one thing that I think is important is that Mr. Hattar posted at the entry of Taylor's a sign that said, if you cause any problems in here, you could be trespassed for a month permanently, depending on the type of conduct and circumstances. The administrative law judge found that Taylor's is the most popular bar in the Eugene area, and especially on campus. Excuse me. That, I think, is an indication that will cause some of the patrons who are prone to cause trouble not to cause trouble because they want to continue to come. The affirmative defenses, if you've read that, I have read, I believe, all of the HSPP final orders that have been issued by the Commission, and there is not another final order that contains as many affirmative defenses that were proven by the administrative law judge. And if you read those, it's set out on a separate page 49 and 50. If you read those, it shows you that each incident should be examined individually for the severity of violence. You can't just say it's a serious incident without looking at the circumstances of each incident and see what those circumstances actually are. For instance, one of the serious incidents that she found was an incident where, close to closing time, a non-patron was walking down an alley and opened a back door that's not accessible to patrons, opened the back door and reached in and shoved a cart tray full of dishes and broke them. Act of vandalism, personal property. The security staff apprehended him, kept him until the police got there, and the police cited him. This is a serious incident, according to the administrative law judge, but it's a lot different in the nature of it than some of the other incidents that involve physical injury. In fact, this is a property crime, and property crimes are to be treated less seriously, but it's still listed as a serious incident. So if you have any questions, read the actual affirmative defenses again, because I think they're very important for your consideration. Also important is the timing. May of 2017 was when Mr. Hattar was given his temporary license. The OLCC was not aware of the incidents that had happened between May of 2017 and May of 2018. They issued no warnings, no nothing, and in fact the record shows that the inspector was investigating a drugging allegation, and he ran across police reports in May of 2018, dating back to June of 2017, that led him to start this process of serious and persistent problems. Mr. Hattar called a meeting in June of 2018, and at that meeting he was told about these incidents that had been occurring. And yes, the argument could be made that he should be made aware of some of them, but the hearings officer found that he was not aware of them. The notes from the meeting show that the OLCC said Mr. Hattar seemed surprised at the number of incidents. And it was from that time, June of 2018, that Mr. Hattar fully realized what the problems had been before and began putting into place some of these programs that he has done.
Let me stop you for one
yes,
second. This is going to be the crux of some of the stuff that I'm going to be asking later on. your whole premise is that the ALJ failed to give sufficient weight to the public statements and the actions that Mr. Haddam took place once he realized the extent of those problems in June of 2018. Now, whether Andrea or you can ask this question, the fourth amended complaint that was filed, and this whole thing goes from May 2017 through the 19th. Your client says that he first realized the extent of the problems in June of 2018. The fourth amended complaint talked about the fact that there were 42 serious, the fourth amended complaint, 42 serious incidents. What I would like to know, because I've looked and I'm not getting through it, you tell me the amount of incidents, one of the two of you, that took place between May 2017 and June 2018, and then tell me the amount of incidents that took place once the licensee realized that there was a problem and then tried to act on that. That's one thing I really want to understand before we go any further.
Chair Rosenbaum, I can answer that question for you because ALJ Gutman actually did that calculation, and she divvied out the number of proven incidents that occurred prior to that intervention meeting in June 2018.
In June 18th, right.
So she found that, so I also want to clarify that our investigation did not cover the entirety of the time that Mr. Hattar had a license. I believe the first incident that it was about a month after. So between June 17th and June 7th, 2018, the judge found that there were 24 proven incidents at the premises, and 16 of those were considered serious.
I'm 24. Now
24.
Tell me the amount of incidents from June of 2018 to now.
And just to clarify, it's not until now. So it was for the remainder of the time that we investigated.
Right.
So for 9 months, the investigation continued for 9 months after that intervention meeting. In the 9-month time period following that intervention meeting, there were 12 proven incidents, and 11 of which were serious.
Okay. So here's my question first to you, Andrea, is from June 2017 to June 2018, there were 24 proven incidents. Why in God's name did the OLCC never issue any violations during that period of time?
It had to do with the process of how the investigation started. The Inspector Foley had been working with the licensee, and prior to that, Inspector Foley and Inspector Whiteside were actually fairly new inspectors, and there was also a new regional manager, and the investigation started, and they began to gather evidence shortly after they began working in the Eugene office. And we don't get those reports, those police reports, as a matter of course necessarily. Inspectors have to take affirmative steps to work with the police departments to request those reports. So as Inspector Foley began his work investigating, that is when he began gathering that evidence. And when that evidence was gathered shortly after they had that intervention meeting, that's when the intake was completed and it was sent up to our department to process and go forward with.
So in that period of a year, there were 24 serious incidents and yet no violations that were actually brought against the licensee in that period of time.
Well, there was one violation, the permitting disorder.
Conduct, I know that one.
Right.
We do read all this stuff.
Yes, I'm aware that you do. Right. There were no other violations that we alleged for that time period, because by the time we got the file, that is simply actually a charging decision made by our department on how to charge these incidents and what to include. Whether we charge an additional violation or not does not speak to whether or not those violations occurred. If we are going forward on a proposed cancellation with a history of serious and persistent problems, that it's a charging decision whether we include individual incidents as well as additional violations. But in this case, we went forward with the history charge as the main violation and did not add additional violations based on the incidents that we found.
So it gives the licensee some cover to say, hey, no violations were actually charged. Now, the question I have to ask you, Counselor, is there were 24 serious violations in that period of time. And I know, I read each one of them. It's almost incredulous that the licensee wasn't aware of those until June of 2018. I had to be aware of them. I like your response to that.
Well,
Unless he's there 2 days a week and doesn't give a damn about his license, and I don't think that's the case. So there were 24 violations. You just can't say they were wrong, in my opinion, of not violating. You can't say you weren't aware of them in 24 of them.
Mr. Hattar, as a witness in the hearing, the administrative law judge found that he was a very credible witness.
I read that.
She found, as a matter of fact, that he did not know of those violations, actual knowledge. Now, whether or not he should have known, that's a different story.
On those 24 violations, and if you want to speak for yourself, that's fine. You're telling me he wasn't aware of them?
Well, he testified of that, and the administrative law judge, in assessing credibility, which is her sole domain, found that that was true.
I guess, Chair, I think the bigger issue is, shouldn't he have known, though?
Oh,
Yes.
Well, that's...
I mean, that's the idea is
Yes.
he should have known.
Commissioner Curran, he should have been aware of some of those because they happened on the premises and some of his employees were involved. Not only were there, as far as violations though, not only were there no violations issued up until June of 2018, except the disorderly conduct with a bartender, there were no violations issued afterwards, either up to and until the time of the hearing. No violations for any liquor law, minors, VIPs, those kind of things.
Chair Rosenbaum, if I can respond to that, that's because there was already a pending action to cancel the license. The commission is not obligated to charge every possible. We also at hearing discussed advertising violations that we discovered on licensees' social media. We did not pursue those. Those are lower level category violations. We focused on the main charge of the history of serious and persistent problem, did not charge those other lower level category violations. That does not mean that they didn't occur. That simply means that we focused on the one charge and the one that had the highest penalty. And also, with relation to the issue of notice, the ALJ, Commissioner Curran, did find, in fact, that licensees should have known of at least those 13 incidents that were on the premises, reported to employees, or involved employees. So whether the ALJ found that he didn't actually know, she did actually find that he should have known. And on top of that, whether or not licensee Hattar had notice of these incidents is not relevant to whether there's a history of serious and persistent problems at this location, because final order precedent sets that a licensee does not necessarily need to have notice for those incidents to count against that licensee. The relevant inquiry is, are these problems happening at this premises? So, and from a policy perspective, that makes sense. The commission does not want to encourage licensees to turn a blind eye to what's going on at their location, because then later on they get to assert a defense, well, I didn't know. The willingness and ability defense is actually an incentive for licensees to be actively involved in addressing these problems, and works to prevent things such as intentional or negligent blindness to what's happening.
You can't have it both ways, though, because in my opinion, there were serious and persistent problems. You knew about it. No violations were actually issued. He knew all about it, too, because he couldn't go away from it. And yet the question is, what did he do about it? I mean, this is just in my head. I'm just thinking out loud on it. That's the issue here. Matt, you have a question, Commissioner?
So May of 17 was when the purchase of this, and then do we have any information predate? I mean, what was there? Does the commission have any knowledge of incidents that occurred prior to that? prior to Mr. Hattar's ownership?
Yes, the commission does. Prior to Mr. Hattar's ownership, yes. And I believe this is in the record and was addressed, that there was a violation asserted against the prior owner for permitting disorder, that the prior licensee, Mr. Hare, had settled with the commission for, I believe it involved bar staff beating a patron.
So it's, I mean, yeah. So it's a college bar. So that's what I was trying to get. I mean, so this is neither here nor there. I just wanted to ask.
Sure. My question is, if we did have so other than, was there been any other violations prior to Mr. Hatter's ownership? Has there, other than that?
Not that were discussed on the record. So with the commission's permission, I'm going to restrict my comments and answers to the information that is contained in the record.
My question, sorry, I'll let you go, Hugh, in just a second. I'm curious because, I can't imagine they just started when Mr. Hatter took over, right? I'd imagine just due to the nature of the bar, it's a campus bar, that it was rowdy when he acquired the bar, when he purchased the bar. So I'm curious why didn't we place restrictions on his license, as we do with many other licensees, to help and assist them be compliant? Why didn't we place any restrictions on the license at the time of his licensure?
I'm not sure at the time that Mr. Hattar purchased the bar that there would be a basis for those restrictions at that point. There was, as I mentioned to Commissioner Miletus, that there was a prior charge for permitting unlawful with the resulting serious injury. But I don't believe in the licensing context that the possibility of restrictions came up. There has to be a basis on which the licensing department relies to instill those restrictions.
It just seems inconceivable that now all of a sudden, since his ownership, that now all of a sudden we're having all these issues, that these weren't there before.
Commissioner Floyd, I want to be clear that we were aware that there were issues at the bar even prior to Mr. Hattar taking over. In fact, Regional Manager Bloom and an inspector visited the location shortly after Mr. Hattar had purchased it, specifically to talk about the reputation of the bar, the problems, the reputation that it had for alleged druggings of young female patrons, and to address some of the other issues, such as a particular drink that they served in a bucket, and problems with excessive intoxication. So this was not a situation where, come June 2018, the commission blindsided Mr. Hattar and said, all of a sudden, all these problems exist. There were interactions and there were efforts between the commission and Mr. Hattar to talk about these issues and address them prior to the intervention meeting, and also prior to the notice, the original notice being issued.
When was the first encounter with Mr. Hattar from OLCC staff?
A month after his ownership.
That was Regional Manager Bloom. I believe it was in May 2017, if not early June. I can look at the report if you'd like an exact date, but it was within a month or so of May or June 2017.
After his acquisition.
After his acquisition.
Is that no, or is there something else?
Why don't you wait till I'm done and then you ask him a question? Is that all right? Or if it
just come back to it when it's your turn.
Hugh's got a question.
You have to understand that in taking over a rowdy college bar, Mr. Hattar did several things right away. Within the first 5 or 6 months, he got rid of some of the employees who had been investigated for possibly putting something into co-ed's drinks. He hired a new manager, different from the manager before, and then when that manager didn't work out, he hired manager Clark, who has been a manager at other bars in the area and knows very well, knows what the circumstances are. So those are some of the things he did
But
within
Mr. Mills?
the first 5 or 6 months.
Mr. Mills, sorry to interrupt you.
I'm sorry again.
That would seem, though, to support Ms. Chiller's position, because you said he did all of these things.
I'm sorry, could you speak
Okay.
right into your mic?
Yes. You said that he did all of these things within the first 5 or 6 months, but yet there was 24 incidents in that time period from when he took on until May of 2018. So there were still, even though he took these steps to fire certain employees, as you just said, there were still serious and persistent problems.
All I can say is that in Taylor's, as other campus bars that has problems, it takes time. It doesn't happen instantly or overnight, and you don't put a program in and it happens Zoom like that. It takes time, and it's, even though he has the ability to solve the problems, it's still a work in progress and always will be. Sure. Taylor's is the most popular bar. Alums, graduation ceremonies, pinning ceremonies, after game blasts, whatever, it's a work in progress. And Mr. Hattar, with his ties to the community, which are in the exceptions, and his ability to communicate with people and the communications that he has done, and also his ability to withstand the financial pressure of dealing with this bar because of the things he's put into effect. Revenue has dropped 20 to 30% year to year since he put in the measure regarding a $20 copay for people who are not patrons. And he did that to get rid of some of the outside agitators. A perfect example is this Mr. Jaffe that I cite. Mr. Jaffe was involved in 3 or 4 of the serious incidents. He was a troublemaker. He liked Taylor's. He liked to come and he caused trouble. He was arrested for various things. He's now been permanently trespassed from Taylor along with others and will no longer be causing problems at Taylor's. And that's one of the things you do and that has been instituted is trespassing troublemakers at the premises.
Mr. Chair. Okay, thank you. Mr. Mills, I also read the information.
Thank you, Commissioner.
And oddly enough, these folks go right to the heart of the issue. I wander into the woods and deal with, the odd details and questions. So bear with me.
Yep.
Maybe some of it will pertain, hopefully. When I was reading about the intervention, and I was scrolling quickly trying to find it, but the intervention, back to the bucket or the buckets that we had, I noted that part of that was that you were going to continue to use the buckets after that intervention until such the supply was gone, the inventory was gone. Is that correct?
That's
correct.
that
right? Okay. But we knew that was a component of the issue, right? Obviously, we're going to discontinue it.
That was objected to at the intervention meeting, I believe, by the OFCC.
Okay. That's helpful. Again, it's kind of window dressing, but it does help. On page 21, item 7, in assessing Mr. Hattar's ability, the ALJ failed to give sufficient weight to other developments in the community in U of O culture. And when I started to read that item there, I was thinking very much like you were mentioning, or maybe a rowdy, I grew up in a college town, a rowdy bar that might be near the campus. However, when I started to read below, it starts to embrace the heritage and kind of the brand of the U of O in a different way, that this is that the bar had significance as part of a historical component. Fully understand that. How was the ALJ to actually apply weight to that, or how would that even come into? their
it has to do
decision-making
with the
criteria.
To me, it has to do with the context in which you examine Mr. Hattar's ability. If you just take the tavern and the patrons in the tavern, that's one thing. The context of him being a U of O grad, and she found that he was very well respected by U of O and by the police of in both agencies. The fact that his history is there, that's the context in which he can get things done. And if you read about the bond project, the police increased patrols that the police are going to have, those kind of things. That's the context in which I believe she didn't make the connection that he is the person who can continue to try and make Taylor's a safe place.
Okay. I appreciate that. Thank you, because to me, I was trying to figure out how it played into the decision. Thank you.
If you could ask a question.
Are you finished?
No, I'm not. I'm not quite finished.
Did you?
Chair,
Yeah.
I'd like to hear from the licensee.
Okay.
Go ahead.
I think what's helped me be successful in this industry, especially in the bars here in Portland and in Bend, is communication. Communication with OLCC, communication with the police, communication with the fire department, communication with everyone involved in the community. And I felt when I took over Taylor's 2.5 years ago, when I was buying Taylor's, my college bar, I felt like I was the right person to take it over because I can have those communications. I have no problem holding those communications with OLCC. My 5 years of doing that in Portland and Bend proved that, and I don't shy away from that. And so I felt like taking over Taylor's and keeping it for the student body, for the legacy of Taylor's and campus, especially being right where it's at, I was the right person to do it. Obviously, I have a lot of ties to the athletic department at the U of O, and so I can have those conversations easily. I communicate with student body, with the dean of students, with campus police. The chief of police for campus is a friend of mine. I call him a friend of mine, and we talk constantly on how to improve things on campus. Like I said, I'm an open book. I'm too stupid to be anything other than an open book. I'm getting sidetracked on everything.
But just as a follow-up, back to the buckets again, the inventory you wanted to run through entirely before you discontinued the buckets.
The buckets.
And just to make sure I got it right, there was something that OLCC was urging you to do, and you opted to cycle out the rest of the inventory. Do I have that right?
Sort of. So we, when I took over the bar, they called them buckets.
Yeah.
They had been there for years. I don't know exactly how many years, maybe 10 years. And they came with the bar. It was the most popular drink on campus. It was the signature
But
drink.
here's, and I don't mean to interrupt,
no.
but if I may, here's the concern I have with that. If there really is an effort, a concerted effort to work with everyone involved and maintain and protect the brand of the entire heritage of not only of this establishment but also the university and the surrounding area, then if you have this, it's akin to saying, well, I'll stop twice at the next stop sign. I mean, you can't, in my opinion, to disregard that kind of advice and cycle out the rest of the runs counter to what I'm hearing myself on that. But that's why I wanted to make sure that this is something that was suggested by OLCC to discontinue, and the approach was we're just going to run out the rest of the inventory before we discontinue. Is that right?
Sort of, but yeah,
Okay.
You're right. And there were a few other things that were discussed, and even going up to that meeting, which I called, I'm the one that requested that meeting. Even going up to that, I was communicating weekly and visiting weekly with the OLCC director and investigators. And that's another reason why I was caught off guard by a lot of the incidents, is because if we were having these meetings, why weren't these brought up? The thefts, of course I knew about them. We tried finding them. We looked through the security footage. I didn't think they were serious incidents. It's serious, obviously, because it's happening in my home. But anyways, and then there were other incidents there were other things that were brought up in terms of ways that we can improve the security at the bar. It's a 100-year-old bar. Mm-hmm. It's been there forever, and I know that I'm the most responsible owner that's ever owned it in that 100 years. In the 2 years I've owned it, I know that I'm the most responsible owner. And I take pride in that.
Well, that's not saying very much in a way.
I was going to say.
Because what you're doing here, the only thing we have to look at, the law. The law says, you forget about the communication, everything. Does this establishment have a history of serious and persistent violations or problems? That's what we have to look at. You had 24 violations between May of 17 and June of 18. You then found out the full extent of the problem. You still had another 12 violations. So answer me this question. If I tell you you can't control the problem, all you can do is mask the problem and tell us about communication. Explain that to me why I'm wrong.
Well, I don't want to say you're wrong. I'm going to say what I'm doing.
No, well, I want you to say I'm wrong.
All right.
I mean, if you don't say I'm wrong, then you're in trouble.
He's wrong. Tell him he's wrong.
He's wrong.
You're wrong.
Okay.
You are wrong, because I know what I am doing there. And I know the efforts I'm making there are working. And I know by, like a 100-year-old bar, let's say it was operated totally different the 15, 20 years before I took it over. I take it over to change the culture of a 100-year-old bar. And what comes with that takes a lot of time and a lot of effort and a lot of money. And I've been putting all that into it. And I know it's paying up. I know right now what I've got, the tailors I own right now is so different than the tailors I bought 2 years ago, 2.5 years ago. And you can ask any of the student body, ask people that are going.
How many days a week are you there?
Depends on the week. Depends on roughly around 3 days a week.
And what do? You come up from Portland, you spend an hour or two, and you go home?
Oh no, well
Well, tell us.
So I'm in Bend, Eugene, and Portland, and I have a pretty good cycle, but it's dependent on the types of meetings I have to have, the types of stuff we got. If we have a home game that week, preparing for that. If we've got things at the bar we need to talk about, new staff, talking about how important. So it really depends, but it's usually a full day. You can look at my hotel. I have a deal with the Phoenix Inn right on campus there. So because I'm there so much, they cut me rates. A lot of times it's too late for me to leave and go home, so I'll stay the night. Many times I stay the night, or I'll stay there for 3 days in a row.
Chair, if I can intercede just very, very briefly, I just want to remind Commission and the parties that we are restricted to the evidence that is in the record, and our decision
We always go home.
I just thought this might be a good time to remind all of us about the parameters of the evidentiary record and our instruction to stay within it. And obviously, the Commission's decision has to be based on what is contained in that record and not matters that were not raised and dealt with at hearing. So I just thought this might be a good place to interject that point.
Yeah. First off, thank you. And what I'm listening for is based on what was found and what the exceptions are. You don't know. Excuse me.
Oh, I thought you were done. I apologize.
That's okay. So you don't know me. I got to Eugene in 1976 as a police officer. I retired in 1996. When I'm looking at the exceptions and I'm listening to you, which is why I wanted to hear you, is I need to determine if you bought a can of worms, if the exceptions are real, because I've been there a long time. Both my sons graduated from the U of O. Of course, I went to the University of Missouri, and so that was a real university. It's about the exceptions. It's about the rules, the regulations. I wanted to hear from you to see if the exceptions were real. I've seen tailors for a long time, not 100 years. So, you know, that's why I wanted to hear from you based on the exceptions, Counselor. I don't need you to read them to me anymore. But that's what I'm going to be looking at. Okay. Thank you, Chair.
Chair Rosenbaum, if I may, just a few closing points. You talked about the 12 incidents since June of 2018, and I invite you to look again at those incidents. I think that several of those incidents, the later ones, show clearly that in accordance with the statute, Mr. Hattar and the licensee have shown their ability to control the behavior of the patrons. And that's an important distinction. The first part of the statute to find a history of serious persistent problems is, does the behavior involve a patron? It doesn't focus on the behavior of the patron. It focuses on, does it involve a patron? That way, if a patron is walking away from Taylor's after a night out and he gets robbed a block from there, that's a history of serious and persistent problem incident. You found that, unfair as I may think that be, that's the way you've interpreted that part of the statute. The second part of the statute, where mitigation can be shown by Mr. Hattar, is can you control the behavior of the patron? That focuses on your patron. Can you control his or her behavior? And if you look at the last 3 or 4 instances, I think you'll show that with his security staff and the training they have and the circumstances, his security people were able to control the behavior. That doesn't mean that you have to anticipate everything that a patron might do, because we all know that when in a drinking environment, people can just change just like that. And in fact, in several of the instances that are the 12, the OLCC themselves indicated in the reports that the staff had no warning of what was going to happen, no advance warning. And in the affirmative defenses, the ALJ found that some of the incidents there was no warning ahead of time, but staff acted appropriately. Take a look at the one again where the logger got upset with some lyrics of a song that was being played by the DJ, and he started shouting to some minority groups and started antagonizing them, and security intervened, told him that was out of line. He started to resist, and as in the words of the OLCC inspector, they wrapped him up like a carpet and took him outside. There were no injuries. They called the police. They trespassed that person, and after that, Mr. Hattar went to that person's boss, told him about it, and the person was fired. He's trespassed from Taylor's. He lost his job over that. That's all found in the record. That shows the ability to control the behavior of a patron. In the other instance, the gun incident, where there was a gun inside the premises, the only reason that's a serious incident, according to the ALJ, is that he did not have a concealed weapon permit. So when he went inside the premises with a concealed weapon, that was a crime. He had it concealed in the small of his back when he went into the premises. Again, there's a specific statement by the OLCC inspectors. They didn't know it was in there. They found out that he was in there showing a gun. They contacted the police. They trespassed the person. The police arrested they trespassed that person and got him outside, and there was no violence or threat of violence in that instance. That's another instance of the ability to control the behavior of a patron. And there are other instances. One last thing, 3 of the incidents that are serious incidents are incidents because my client instituted keeping a bar log that keeps track of everything that goes on. 3 of those incidents would have not have been known to the OLCC at all if the bar log had not been available for them to review. And there was no other police report, no nothing. They took it right off the bar log and turned it into a serious incident, which is one of those 12 that you're considering. So I believe that you have sufficient evidence to find that Mr. Hattar certainly has the willingness and also the ability to adequately control the behavior of patrons in the premises and in the immediate vicinity. Thank you for your time.
Thank you, Councilor.
Open to questions.
Chair Rosenbaum, Commissioners, thank you. At the outset, Commissioner Miletus, I want to correct an earlier statement that I made. It was October 2017 that the regional manager inspector met with Mr. Hattar.
Okay, so
from May,
June, July. Okay, I gotcha. Well, thank you.
Wait till question.
I want to start by reminding the Commission that according to the law, our final order precedent, the way we measure a licensee's ability and willingness to control the premises is whether or not the number of incidents has been reduced. And I'm going to address some of the specifics. I just want to make sure I emphasize that again. It's not whether injury occurred to patrons. It's not whether certain types of incidents have been reduced. It's whether the number of incidents taking place at the premises has abated. And looking at the evidence presented to her, Judge Gutman determined that at no point during the entire process investigation time period that is relevant to this proceeding did the number of incidents decline. So first, we've heard a lot about steps that Mr. Hattar has taken. And I want to emphasize that it was not the Commission's position that Mr. Hattar sat back and did nothing. We acknowledge that the steps were taken. We acknowledge that changes were attempted to be made. However, based on the continuing number of incidents, those changes were not effective. And as final order precedent says over and over again, it's not intentions, it's not efforts, it's results. You can make the laundry list of changes that Mr. Hattar made and still come to a conclusion that he does not have the willingness and ability to control the premises because these incidents have not stopped. So,
could I ask one question?
Sure.
Would it be accurate to say though there was increased scrutiny? I mean, there was increased attention on how many incidents were occurring. Would that
Commissioner Miletus, not necessarily, because a lot of the evidence that we relied on were independent police reports. So when Inspector Foley began and Inspector Whiteside began looking into Taylor's, one of the first steps is to collect police reports. So that's from an independent agency. The police, I'll be honest with you, the police actually do, and police officers testified at hearing that they do pay a lot of attention at Taylor's because as multiple officers and sergeant testified to, it was a cause of a lot of problems in the area. So there was scrutiny, but not necessarily increased scrutiny because of this particular investigation. So I think there's two important things to keep in mind when we're talking about these efforts. One is steps that actually weren't taken, and the second is the timing of the steps that were taken. From very early on, from that October 2017 meeting and including the intervention meeting, one of the problems that was repeatedly addressed was the overservice of alcohol and the intoxication level of the patrons and the crowd levels in the bar. Officers and inspectors communicated to licensee and the staff that a crowded bar full of drunk people creates a heightened risk of these incidents to occur. And as Commissioner Palcic pointed out, the bucket was pointed to early on as a problem. In fact, Regional Manager Bloom pointed out the buckets as a problem back in October 17. It wasn't until the intervention meeting in June 2018 that Mr. Hattar said, okay, we'll stop. And what he said, the statements on the record, is we'll stop that right away. It's done tomorrow. There's video evidence of August, 2 months later, those buckets still being served. We actually don't know when they were actually served. We have video evidence of mid-August. We have social media posts showing that they were advertised on August 14th. But 2 months later, they were still being sold. There were other alcohol-related steps that could have been taken that weren't. For example, up until March 2019, right before the hearing, Taylor's was still advertising drink specials, including reduced prices for shots, dollar beer nights, all event specials that encouraged rapid and overconsumption of alcohol, specifically when the overconsumption of alcohol and intoxication levels of patrons was specifically pointed out as a problem, as fuel to the fire to these problems. And you talk about changing the culture of the bar. A lot of time was spent at the hearing talking about that culture, and that it was a culture of a lot of young college students drinking a lot of alcohol. That's, as an owner of the business, there are steps that could have been taken to de-emphasize the rapid and overconsumption of alcohol. Those steps were not taken. There was discussion about pour control. So bartenders pour out of a bottle. It's commonly known that 4 seconds is approximately a shot. And there's video evidence of bartenders pouring extremely long drinks, holding that bottle up for 4, 5, 6, 7 counts. We have video evidence in the bar of, again, March 2019, immediately before the hearing. The same heavy pours, no measuring devices, no efforts to restrict the amount of alcohol in these drinks that are being served to the patrons. The crowd levels were also specifically addressed. And again, Mr. Hattar testified at hearing that the door staff began using counters to try to control the number of people that entered the bar to address the crowd level. There's video evidence, again, in March 2019, video surveillance of the front door with no such counters being used. So, again, we're not saying no steps were taken. We're saying the steps were taken were not sufficient and did not address the serious issues of over service and crowd levels in the bar.
Andy, if you wouldn't mind, was there ever, you mentioned crowd levels. Were you ever non-compliant with the fire marshal? Did you ever have any non-compliance in reference to overcrowding?
No.
So how is this if he's compliant with the fire marshal?
Commissioner Floyd, the fire marshal attended that June 2018 meeting specifically because of concerns of overcrowding. There was testimony at hearing about the difficulty of enforcing that. Basically, they would have to stop the operation of the bar, pull out all the patrons, and count them to make sure that they were within code. And from what I understood, that was what was testified to, is that that's very disruptive and not a common occurrence. But it was the fire marshal had a concern that they were exceeding their level, even though it didn't rise to the level of, we're issuing a violation, we're going to stop your operations, we're going to count the number of people in here.
But he never was cited.
But he was never cited. And separate, there is the occupancy level, which is set in its rules.
Right.
But there's also a security issue. Even if you're technically allowed to have 150 people in your premises, if you have dim lighting and crowded people and a lot of alcohol, your security staff is not going to be able to see incidents before they occur. You're not going to be able to be in there with the people. So while technically the licensee had the ability to operate at a lower level than legally allowed, and it could have been a security decision to say, we can better control this premises, we can be proactive about addressing these problems if there were fewer people, if there weren't patrons packed into a dark dance floor where we can't see what's happening, especially because when the allegations and the initiation of the investigation had to do with drugging of drinks. No matter how many DPSST certified security staff you have, if they can't see what's happening, they can't be effective.
Sure. But in fact, didn't your client, Mr. Hatter, didn't you increase lighting at the dance floor, LED lighting, flood lighting?
Actually, what was testified to at hearing was that there was an engineer who did a study, but at the time of the hearing, that lighting, that was a proposed change, but there was no evidence that it had actually been instituted. And also that dovetails into the next point I was going to make about the timing of the changes. So from the intervention meeting, which was 2018, there were, and it's in the proposed order, a laundry list of changes that were made in late 2019, either March, May, or June 2019 on the eve of hearing. There is final order precedent that states that changes that are made late should not be taken into consideration because there is no way for the fact finder to determine what the effect of those changes would be, right? Because again, it's not that the changes were made, it's were these changes efficient and effective in addressing the problems that are happening. So if in March 2019, Mr. Hattar changed the lighting, there is no way for this commission or the ALJ to determine that that would be an effective way to address the problems. And without that second piece, without the ability to determine the effectiveness, it cannot be considered in determining whether or not Mr. Hattar has the willingness and ability to control the premises.
Can you think offhand of an effective thing he could do?
That's a good question.
Me personally, Chair Rosenbaum?
Yeah, I don't have anybody else to ask, so I guess I got to ask.
Well, the commission is not generally in the position to tell businesses how to run their business and what to do. I can look at final order precedent and say when there have been findings of willingness and ability, what they've done. In certain cases, they changed it from a bar to a tavern, more focus on food, less focus on alcohol. In one case, they removed the lottery machines to change sort of the tenor of the place. Those are sort of the steps that have been found previously to substantially change the operations.
Okay, Mr. Chair. To that point, and I agree, if you're going to actually apply a measure, you'd like it to be measurable. You'd like to be able to know on a matter of facts and data whether or not it actually is of impact and importance. There was an item in October of 18, the $20 cover charge that was put into play for Friday and Saturday nights for non-students. And building on that is the fact that there was a counting device that was used at the door. So do we have, and I'm back to facts and data on this, do we have, this one might be measurable. Was there any kind of count, any kind of variance, any kind of, what does the delta look like from when this was implemented to what's happened? And I guess the end result might be you still ended up with these instances happening, but that's one that might fit. I also wonder, just aloud, and I'm sure that non-students, alums and so forth, might be present and might want to enter a $20 cover. I could see how that might deter some, economically from, entering, and that might help your numbers. But it's for non-students, and the proximity to the university, I think it might. I don't know how impactful that was, and I'm wondering if there isn't anything, if there is a measurable data point that we can look at for that.
Commissioner Palcic, for the counters, I would make 2 points. One is there's video evidence showing that they weren't implemented, and then the other thing we have is surveillance video from inside the premises at a date afterwards. Sure. And again, it's anecdotal. We don't, it's a certain snapshot at a certain time, but the
You just answered my question, though. If the data that we would have would be suspect, and if there's evidence that the counters were not being used at times, I think that actually it deters the credibility of that data. So never mind. I answered my own question.
But if he doesn't have any, if the fire marshal isn't on his back and he hasn't been cited by the fire marshal, I don't understand why this is why is that an issue?
It's a good question, but you had the fire marshal. There's a reason the fire marshal is part of that. We're in deliberations.
I guess, Mr.
It's not the legal issue, but we need to discuss it. You know?
Yep.
Commissioner Floyd, I can explain our position on why it matters. Because there are, just like all of these measures that Mr. Hattar did or could have taken, they're all voluntary. So he's not mandated to take any of these steps. So lessening the crowds in his premises is not something that was mandated to do. He could have affirmatively and proactively taken the step to say, a crowded bar leads to more incidents. I've communicated with officers and individuals at OLCC, and they have informed me that these types of circumstances can lead to more incidents. So I'm going to be proactive. And even though I'm legally allowed to have 180 people, I apologize, I don't know what the exact number is, but I'm legally allowed to have X number in the bar. I'm going to decide to try to cap it at B to see if that helps. So he is legally allowed. There's a distinction, I think, between what you're allowed to do and what you can do to try to address the problems.
May I respond?
I'm going to get, you really can't, but I'm going to let you. Go ahead.
I appreciate that because the counters were being used. The time of the evidence was not on a Friday or Saturday night. Their busiest nights where crowd control is necessary, or on a game night. And we talk about the expense of the DPSST. That's his biggest payroll expense, he testified to. And yes, he engaged an LED engineer to look at the lighting. We can't tell you the results of that because it's not on the record. The crowd control, their busiest nights are Friday, Saturday, and game nights. The rest of the time, there's times you can walk through there and, one or two people at the most. So Friday and Saturday nights are the nights they focus on where they have the extra DPSST, where walkie-talkies are used, where counters are used, and so forth. It's speculation for Ms. Chiller to indicate that he didn't consider crowd control or that the crowd decreased or increased or stayed the same. I think Commissioner Floyd's observation is a good one. If he was having trouble with crowd control in a legal sense, where were the fire marshal things? All of the steps that he took, and if you read the exceptions regarding the steps he took to lessen the drinking culture that was on campus and at Taylor's as the most popular bar, he instituted those. Just in closing, I'd say that I told you that the HSSP final orders I'd reviewed, there were never as many affirmative defenses found as in this case. Also, in the same final orders, there is never a list of things that the ALJ found that Mr. Hattar put into play as in this particular case. You can read them all, and there's 3 or 4 pages of her findings on what he has done to do that. And I say, again, look at the last 3 or 4 serious events and incidents, and I think you make the determination that it does show that in those instances, his people are able to take care of the patrons.
Chair Rosenbaum, if I can respond.
And that's it. Yeah. Go ahead.
The video surveillance from the entrance of the building was from Saturday, March 9th, because it was from the date that the individual came into the bar with the gun. That was when we had video surveillance. It was Saturday, March 9th. 2019, video surveillance from the front of the building showed that no counters were being used.
I have no way to prove this, but of the 42 serious incidents, I would imagine an overwhelming percentage of them took place on the nights that crowd control was something of importance to the organization. But that's, listen, anybody have anything else to say? Go ahead, Commissioner.
I'm like the commissioner that really cares about people.
We don't.
Well, you.
Don't.
Oh my God, we're at a
We're
at a debate. Are we in Vegas right now? What's going on? I also had a child that graduated from the University of Oregon. We also know law enforcement in Eugene, and we also know people on the university campus that really want to promote safety and the culture of being able to say not only no to excessive alcohol, but yes to life. These numbers in regards to the infractions that occurred at your place of business is egregious. It's terrible. You got to admit it. You're not disputing any facts that's in this report. You're talking about responsibility. It's not there. I talk about the safety of my kids going out and enjoying themselves in the evening and coming home safe. I talk about athletes going out and wanting to show after a big game to be around that crowd that's really promoting them and making it home safe. We get to the point where we know that you've taken this business on yourself, and it's not our position to have any procedural changes or give you any preventative measures to make your business better, because it's all about you. If we took that on, we'd be doing it for every business in the state of Oregon, and definitely the governor of Oregon didn't give me this prerogative to confirm it and then allow you to maintain your license, as we know, or I know, that something else is going to occur because you have not been willing to change anything. I don't care about a posted sign that says Oregon Liquor Control back in the back. That sign don't mean nothing to me. I want to drink. So what I see us as commissioners doing is reading this report and going back in the back and saying, dude, you got businesses in Oregon and in Portland, and maybe, and you're doing a great job here. You know, it's Oregon, Eugene's tough. I have a law enforcement officer right here that'll tell you ex officer that doesn't want to be in the streets every Friday, Saturday, and Sunday sitting outside your place of business, and then you turn around saying, well, you deterring my students from coming in there because of this activity you have. Yes, we will not know every infraction that a business has until it gets to the point where you are today. And I just wanted to say that because I'm struggling with our questions, because I care about the people that's coming into your place of business. And remember, all money is not good money. You start charging $20 a cover, I hate that. So, I mean, I just had to get that out of me, Chair, because of the fact that you are, thank you so much.
Do they have the right to respond or
No.
make any statements?
They don't.
No, we're done.
Okay, all right.
We're done.
But
Any other comments from the commissioners?
No.
Since I've been chairman, when we've had these hearings,
Chair. Commissioner Miletus.
No, I'll save it till later.
since I've been chairman, when we've had these hearings, I've allowed a great deal of latitude because I think it's important. All right? We're not in a court of law. We don't have to abide by the specific rules and procedures. This is a man's livelihood. We understand that very well, and we take our job very seriously. We're going to go in there and debate this, and the reason I just bring this up is for those people in the audience who are not cognizant of this, but each one of these commissioners, including myself, are precluded from talking to each other about this particular case or any contested case We have no idea of how the others, you see all of it coming across because we've never had a discussion on it. We've read all the material. Now we're gonna go inside and we're gonna have it for the first time, a discussion about what we're gonna do. We do take this very seriously. And we are now, the commissioners will now go into chambers for deliberations on contested cases pursuant to ORS 192.690 sub 1. Once the contested case deliberations are complete, we will then return to open session to make decisions on the contested case.
Thank you.
Commissioner Curran?
In the matter of the full on-premises sales license held by Zidane Outdoors LLC doing business as Taylor's Bar and Grill, I move to adopt the proposed order and to issue a final order canceling and refusing to renew the license.
Commissioner?
I'm going to recuse myself from this matter. I've disclosed the potential conflicts, and I'll be recusing myself. Is there, Kelly, is that?
Take the roll, please.
Commissioner Kern.
Yes.
Commissioner Floyd.
Yes.
Commissioner Harper.
Yes.
Commissioner Miletus. Recused.
Recuse.
Commissioner Pasek.
Yes.
Commissioner Raval.
Yes.
Chair Rosenbaum.
Yes. Thank you.
Is there? Can I mean, I just want to put a couple things. This was one of the most challenging cases. I think there was a lot of discussion back there. This was very difficult. I know Ramsey personally. I know what pride he takes in his businesses. I know how incredibly hard this was. I had no choice but to recuse myself, but I do want to say I think that this commission is going to look at a few things, and it's for what it's worth. I truly empathize with you, and I understand how tough this is. You've got a lot of people that are supporting you, and I'm sorry for you that it went this way, but I understand why it did. And, hopefully everyone can move on from this, and the agency can improve as well as your operations, and we'll all move on from it.
Thank you.
Compliant.
Okay. Oh, thank you. Okay, the next thing is compliance, ratification of commissioners to stipulated settlement agreements. Mary Ann, thank you.
Good morning, Chair Rosenbaum, members of the Commission. My name is Mary Ann Christian, and I'm with APP. And today we have a number of stipulated settlement agreements for your consideration, starting with 8 alcohol violation agreements. And I can answer any questions you may have.
Anybody have any questions?
I do, Chair. On number 4 with Safeway, when is it permissible for licensees to accept gifts from wholesalers and manufacturers? Is this a violation because the assistant sales manager solicited himself for the tickets?
For the record, Kelly Rout, Director of Administrative Policy and Process. Financial assistance questions are very tricky, so I knew that I'll just go ahead and take this one.
Thanks.
So under statute and rule, it is generally prohibited for suppliers to provide things of value to retailers unless specifically allowed. So in rule, we have very specific exceptions as to what can be provided. For example, a supplier could offer to take as a guest a retailer to a sporting event, as long as they accompany them. But a supplier could not just give a retailer sporting event tickets and say, go on your merry way. That's a thing of value that's prohibited. It is also prohibited for the retailer to solicit those things that are prohibited for a supplier to provide. So that's why we're here today, because he went sort of off script and just went out and asked for tickets, which would have to just give them to retailers. It wasn't the situation where a supplier would have asked a retailer to be a guest at an event.
Thank you for the clarity, Kelly. You know, this gifts and sporting events tickets given to licensees by manufacturers, and it happens quite often. quite often. So thank you for the clarity, and I would hope that licensees are hearing and that they would know, because, I mean, it would be accepting under, they wouldn't know.
Commissioner Freud, you are absolutely correct. There is potentially a lot of noncompliance in this area. We do, our department does communicate with the distributors and do provide training to distributors and that sort of thing at their request to provide information about the intricacies of these rules, because there are certain things that are allowed and a lot of things that aren't allowed, and things sort of slide over time. And so we have to try and rein it back in. So we don't see a lot of these violations because we don't receive a lot of complaints about these violations. And they are sometimes they are hard to see out in public because retailers are allowed, for things that are prohibited, they are allowed to purchase them for at least cost. And so you might see something that's branded at a premises, but you don't know offhand, did they buy that? Were they given that? So it's kind of an interesting area.
So if our licensees accept tickets to a sporting event by the wholesaler, who's accountable for that? Would the licensee be accountable for that?
Right. So let's say a supplier gave a retailer tickets and it wasn't allowable. Likely the supplier, and we would likely propose to take action against the supplier and potentially the retailer for accepting that, because we have rules against the suppliers, but we also have a rule that says that retailers cannot accept or solicit those potentially. I mean, it's always a case by case basis, right? So it's something to be wary of.
Just to clarify, though, there are some circumstances where
there are things that are allowed. Absolutely, right. Yes.
And I think we just have to make sure that the industry folks are mindful of those rules, because I think they don't. Yeah.
Right. It is an area where, things get missed.
I think if we shine a spotlight on it and we're saying that all that activity is not allowed, I think that it maybe causes a misperception, because there is, I won't go down that road.
But as a person that did this sort of analysis for a few years, I would hope that there were more people that were aware of those rules.
And a quick question. We have two cases that involved altercations or fights at their locations. And I want to share with me about how these numbers start racking up. So we have two businesses that both had fights, one on premise and one that came from the premise and moved out on the streets. And they received the first level category 3 violation. What's the next violation after another fight ensues? If potentially there was an allegation that another fight occurred. Make sure I said that legally.
Commissioner Harper, if there was another proven if we found another violation to allege, the facts were sufficient. If it's within a 2-year period of the first incident, it would be the second level of Category 3 violation, which is a significant increase in penalty.
Okay. And at what level would we opt to cancel their license?
After the 4th within 2 years.
All right. Thank you.
Go ahead.
No, go ahead, Commissioner.
And of these cases that you're looking at here, what record do we have about what the historical issues have been at these locations?
Commissioner Reval, whenever we have a violation in front of us, we do pull their history card to see what number of violations they've had in the past 2 years. We can't really, for the purposes of the penalty, we don't consider violations that are outside that 2-year period. But, if there's potentially a pattern there, that's something that we would likely communicate to public safety. There might be a larger problem there. Does that get to your question?
Yeah, what I'm trying to get at is the difference between licensees as business people and locations as simply being a problem location. So I'm worried about that at this point.
Right.
And so do we know that about these locations that these stipulated?
These are likely premises, Commissioner Reval, that have one bad night. When we're looking, for example, we just did a history of serious and persistent problems cases. That's not all of those incidents necessarily would have risen to the level of violation, but the totality of the circumstances showed that there was a problem premises. Here we're dealing with, they're more likely than not, based on the facts that we have, just sort of moving along, but they've had a bad night and a violation was proven, so we take action. We would be informed by public safety if there were ongoing problems, and we would be evaluating a different type of violation for that, or an additional violation.
Chair, are we also discussing the marijuana violation as well as the licensing stipulated settlement
No,
agreement?
separate.
We're doing that separate?
Yeah, we'll do
Okay,
that
good.
separately.
This right now is just alcohol?
Right.
Okay.
Is Mark in the room? No? Will somebody get my message to him? If there was ever a name of a bar that matched the deeds, it's the Ugly Truth Bar and Grill. And I just think that the people in John Day, it's close to me. I'm going to vote yes on everything, but you know, this is the classic example of people in John Day should know about this.
Chair, I move to ratify the 8 stipulated settlement agreements as proposed by staff.
Commissioner Kern,
Yes.
Commissioner Floyd,
Yes.
Commissioner Harper,
Yes.
Commissioner Miletus,
Yes.
Commissioner Pasek,
Yes.
Commissioner Raval,
Yes.
Chair Rosenbaum.
Yes. Boy, it's going nice and smooth, actually. I like this. We're on the marijuana ones now.
Thank you. For your consideration, we have 3 marijuana violations stipulated settlement agreements and available questions.
Any questions? I have one very simple one on homegrown apothecary. You've got 3 category 1 violations. Is it just a matter of rule that if you find it all at the same time, you're just going to charge them for one?
Chair Rosenbaum, we allege all 3, but we can only really cancel once, propose to cancel once. We can't. So, and I think this one is one where they are agreeing to surrender their license, I believe, because there were 3 category 1 violations. This is likely not one where we would have allowed them to continue to operate for some lesser penalty. So it's either contested or surrender.
I understand.
Okay.
Is there going to be any situation where you have 3 category 1s that you would have a restricted license or no
Chair Rosenbaum, anything is possible. I think it would depend on the facts of the case and sort of the circumstances of those violations. We do have a number on the marijuana side of violations that are classified as Category 1 that we will evaluate because potentially they may no longer need to be a Category 1 violation. So that's a longer discussion. Taking that into consideration, sometimes we do reduce those depending on the level of corrective action that is taken and sort of the seriousness of the violation. Yeah. So it could be possible, but I don't know that we've done that to date.
Well, and not to prolong this, but when there's 3 category 3s, I understand that. When there's 3 category 1s, I don't understand that.
Mm-hmm. Right.
Okay. Can I get a motion, please?
Chair, I move to ratify the 3 stipulated settlement agreements as proposed by staff.
Commissioner Kern,
Yes.
Commissioner Floyd,
Yes.
Commissioner Harper,
Yes.
Commissioner Miletus,
Yes.
Commissioner Pasek,
Yes.
Commissioner Raval,
Yes.
Chair Rosenbaum.
Yes.
Thank you. And then the last item is a licensing stipulated settlement agreement for your consideration.
This is, Chair, sorry.
Yes.
This is the one that we're proposing license restrictions on, correct? This is it. Prior to it being Club T's, was it also called Skin? And prior to that, JD's Bar and Grill?
Yes.
Yeah. I recognize the location very, very well. There's been an onslaught of very serious incidents that have occurred at this location. Just a few years ago, there was a 29-year-old woman stabbed to death. A year prior to that, there was a man shot to death. And a few years prior to that, another man shot to death at this location. Unless we feel that this licensee is going to completely change its model and its business practice, doesn't appear to be so, and attract a whole different demographic of its customer, I don't see why we would issue a license here. A wise person once told me that The definition of insanity is doing the same thing over and over and over and expecting a different result. I think this is insanity.
Commissioner Floyd,
Experience.
what as staff we did look at all that. What we're looking at in this particular license restriction is whether the exclusion of specific individuals from the premises and the business based on their prior history and being a risk to the business, along with these other restrictions, are sufficient to decrease the risk that you're talking about. It is staff's contention that this will improve things. It's ultimately up to you to determine whether that is in fact true, or should it go forward, the time would bear out what will happen.
These individuals, I don't think were even involved, years prior when one man was shot, then the other man was shot. I mean, there's been multiple murders, but then on top of just injuries. I mean, it's a problem area. It's a really bad area. And the demographic of their customer is the demographic of who enters into this strip club. That's the problem. We just took away a guy's license a second ago. And here, where there's been multiple murders, we're proposing license restrictions.
Commissioner Floyd, is that in here? That information on the record?
No, but if you can Google it, it's in my area. I know it very, very well. You can check the media.
I think it's worth talking about.
I understand, but it's going to be difficult to take into consideration, I think, for people. I have to consider what's on the record.
I think you're right for this one, but we only get so many hours that we're in here, and I do think that we're fresh off of a case that I think is probably some precedent should be set as a result, and I think Commissioner Floyd's comments in result to this are somewhat timely. I don't know that it should necessarily affect the action we take because we haven't done that, but I think that while we're having this discussion, it's all fresh in our head. It might behoove us just to. I think her comments are helpful, but I also think I agree with Commissioner Curran that perhaps it's not something we can address with this one, but we certainly make a note of it and maybe instruct staff to do something differently next time. I don't know. That'd be my 2 cents.
I mean, it's not hidden information. This is, it was in the media, covered very, very well over and over and over. It's a problem area in Northeast Portland.
Chair.
Maybe. Yes.
So my understanding is that the restrictions is that these two people who want to be allowed on site would still be allowed to be compensated?
They are the landlords of the property, so they have a financial interest in the business through that way, but they're not permitted to be within the facility or operating the business. There are also the additional restrictions related to their video surveillance and service of alcohol, patron entry and re-entry. So it's more than just these two individuals.
We're in a situation where the organization as a whole, it continues to mature. And in that maturity, it is determining whether or not the licensee is a poor licensee or if the location is a poor location and a poor organization. I guess back in the 60s, we said bad karma. If the location has bad karma, and I'm concerned about the karma of this location as opposed to the licensees. We may not be able to keep someone from having it, but I guess I would like more information about the historical issues that are affecting this location as opposed to the individuals who are running it. It will probably, unless you can give me some information, I don't feel comfortable moving forward with this particular situation without more information.
And just to sorry to chime in, but we may be doing these individuals a disservice by giving them this license, as we saw with the last case we just had. Granted the individual license for a place that had a lot of issues. I am speaking only for myself. I know that individual to be a good operator in a bad situation. This is a bad situation, according to what I'm hearing from my fellow commissioners, and we are granting these individuals a license. Now, this thing goes bad, which it has, it sounds like a few times before. That person, if their livelihood is in the bar and restaurant industry, is going to have an issue getting licensed again. So I just think we need to be incredibly mindful, bearing in mind what just occurred with the contested case, bearing in mind what Commissioner Floyd has brought up. And granted, this may not be the appropriate time or forum, but I think it's in all of our heads right now, and I think it has to be said.
Chair.
One second, Commissioner. Go ahead, Steve.
So, Mr. Chairman, and everyone hasn't spoken yet, so maybe we should let that happen. But I'd say in this case, we don't have to take this action today. We can take a look at the restrictions. We can take a deeper look at what's happened on the site and come back to you with a more thorough recommendation on this. You obviously have those opportunities on how we manage the property and what operations and what restrictions we put on. It's clear to me that the commission wants to give these extra scrutiny.
You're pretty astute in counting the votes, so I think you're right in saying that this probably should be tabled for today. The question really comes in is without the commissioner's knowledge of that area, we would have been in the dark. I have gone on record and voted against all of these licenses at this point because of the potential liability. The more information we have on these type of cases, the better off and the more informed we are to make a decision. So if there's any of these commissioners that object to it, as chairman, I'll move to table this. I'll ask you to give us the full background on it for the next meeting.
I just want to go on the record and say I'm disappointed, and I was ill yesterday, so I feel like I'm a little short because I haven't eaten anything in about 24 hours. But I am a little bit disappointed in how short-term our memory is, in what we did to ourselves last time, in not giving this commission the agency deference to, they know so much more than we do. And if it was just a couple of months ago where we said, no, we want to send you back to terminate this lease, and then all the facts came back to us, and we said, oh, and they got the license cancellation just as we directed them to do, and then they stood up here and we went back to deliberate and said, well, maybe we should have not canceled this license. Maybe there were other facts that we didn't know about. And I keep telling people, or the commission, that there is a reason we can't know these things. I don't want to weigh what Commissioner Floyd said because it's not on the record. It's not my job to be, her facts may be actually correct, but I trust the agency and what they're putting before me on something like this. And
Sorry, go ahead.
I guess I want to say I'm disappointed because I feel like we got ourselves in a sticky mess last time. And it's okay to inquire and make questions, but at some point, we have to understand that they have so much more information when they're deliberating in this. They are speaking with these people. They are on the ground with these people day in and day out. And when they bring this to us, they're saying to us, we have reached an agreement. And it's not whether we are telling this business owner, we're setting you up to fail. That's the business owner's choice. That's what we live in this country. They can make that decision. If it's frustrating to me that we as an agency have come to an agreement with the licensee, and we are going to go all the time and effort that they have done and say, no, we're not going to accept that. So with that said, if you feel like you need more information on that, that's fair.
We can take a vote and then we'll figure it out.
So,
or we can move to.
I agree with Commissioner Kerr, and the staff does an incredible job. They have information that we don't have. What I would just add to that, because I was in agreement last time when I said, the longer we are in these positions, the more adept we get at understanding the system, the more we understand the responsibility that's kind of put on our shoulders, I think it's incumbent on us to look at the overall processes that we are engaging in and where we are repeatedly seeing hiccups within the system that as commissioners, maybe it is incumbent on us not to do it on the fly. And I think, we're maybe all a little bit fresh on this, but to really look at where there could be areas that policy that could be improved, because you are correct. The staff is expert at implementing the policies that we direct them to implement, and they have more information than we do. But I do think that there are some areas where things can be, slightly looked at or improved. And but yeah, that's just my 2 cents.
Chair, I would move to ratify the stipulated settlement agreement that was agreed upon by our agency and by Club Tees as proposed by staff.
Any further discussion?
Chair, and I agree with Commissioner Kieran also. In the synopsis, it says that there are individuals with a financial interest in the business that may be unlicensable due to past noncompliance with OLCC regulation. Is that the 2 people here, that the owner of the building?
Yes.
Okay, and then also it says that they've been in operation for 90 days already.
Go ahead.
The Club Tees has been operating under a 90-day temporary authority, and it was extended for an additional 30 days. So they've been in operation for 120 days without any
incidents. And also, our report also doesn't. I mean, people here in the audience and as commissioners can sort of think that Club Tees means, nudie bar. But what do they do in Club Tees?
It's a nudie bar.
All right, thank you.
Is that defined in the statute?
That's
a definition. Is there a definition?
Because you don't.
It is in fact a strip club.
Okay.
An establishment where dancing is offered as a form of entertainment.
I'm sorry.
Any other discussion?
Old. Call for the question.
I am going to vote no. And we had this conversation 3 months ago on these restricted licenses. I brought up the fact, from my personal point of view, there is a potential liability issue. I'm not voting yes on it at this point. And if in fact there were 3 deaths in the place and shootings, and we're not even aware of it, I understand Commissioner's current point, and I think she makes a lot of sense on it. But from my personal point, I'm voting no.
Is it time call for a vote?
Or can I know we have a motion sort of on the floor.
We have a motion, but we're
If
going to have a
it's okay.
discussion anyway.
And this is what I was trying to ask earlier. Are we missing something? And I don't mean that to second guess or judge what's going on here, because it just seemed like we were wrestling with it, and I didn't know if there is something if there's more to the story, so to speak, for what we need to have for context. Perhaps if the timing works, that we can bring this back, that would be great. If this is indeed where we are and it is a stipulated settlement, then we can
It'll
move
get them
forward on
right
the
to work
motion.
right
It's
away.
here.
They'll get them to work.
Yeah, if we pass this thing, that's it.
They can get to work.
But are we missing anything here is what I'm after, because there were things that were brought up.
Commissioner Palcic, I personally am not familiar with the facts of the case and when these particular incidents occurred. When we are evaluating an application and potentially problem area or past non-compliance, we are also weighing good cause factors like passage of time. So it could be that these things happened at a time in the past. I don't have that information. I think it's worth taking an extra look. I would like to note for the record that this applicant has been operating on a 90-day authority, and then it was extended 30 days. So I believe it expires very shortly. So if we continue to look at it, there will be a lapse in operation of alcohol sales. That is what it is, but I just wanted you to make you aware of that.
Were you aware of the fact that 3 people were killed at this place over a period of time?
Is that a fact?
I don't have that
fact.
information.
We don't have-
I don't have that information.
That's exactly my point. We don't have the fact. It's not on the record.
I can't consider that.
I know you can't consider it. My question is, should we been apprised of it somewhere? I know we
Chair
can't
Rosenbaum.
consider it.
Chair Rosenbaum, if I could, in crafting these documents, public safety staff are involved with licensing staff, and this goes through multiple reviews. Staff that was involved in this has full information about the history, the location. They would have been talking with law enforcement and have figured out that this is a risk that this owner would like to take.
Got it.
And that we believe at the staff level that these restrictions are going to get the job done, and what we've seen is 120 days of it getting the job done.
Sure.
Yeah.
Commissioner Kern, I got my other additional information. And you know how displeased I was 2 months ago in that situation. So call for the question.
There we go. Call for the
We have a motion on the table.
Yeah,
I've moved to approve the stipulated settlement agreement.
Commissioner Kern.
Yes.
Commissioner Floyd.
No.
Commissioner Harper.
Yes.
Commissioner Molinas.
Yes.
Commissioner Pasick.
Yes.
Commissioner Reval.
Yes.
Chair Rosenbaum.
No. Thank you. Motion is
Thank you.
passed. What I want to do is go to the renewal approvals, and then we'll take a 10-minute break, and then we'll go to the other ones, yeah. So can we do the renewal approvals? And this shouldn't take very long.
What? Yeah. Sure.
I should do that now.
Yeah.
Mr. Chairman, before this starts, I just need to put on the record that we do evaluate incidents and crimes and deaths within a bar. Remember that it's attribution of the sale and service of alcohol that we look at in there. So there may be a death. It could be a spouse that comes in out of the blue, stabs the other spouse. We don't necessarily hold the bar responsible for that action. So, the fact that there's a crime or crimes in the related area that involves deaths are evaluated in the process. I can't tell you specifically on the case you just looked at, but I can tell you the process weighs those.
Well, it's easily Googled, and that wasn't the case here. But
No,
okay, let's do these quick.
Chair Rosenbaum, Commissioners, good afternoon, I believe. Brian Fleming, Director of Retail Services. If you would like, we can entertain the first two pieces, which generally move pretty quickly, but we can also postpone that as well. So under your first tab, you have the contract renewals. This is, as I mentioned before, February and August, we renew the contracts that will be coming up and beginning in July. 8 of these are for a 5-year contract renewal. The remaining 8 are for a 10-year contract renewal. Like I mentioned, I am happy to answer any question as it relates to the current contracts for renewal.
I have one quick one.
Yes, sir.
What I've tried to find out here, is the criteria between 5 and 10 just how well the store has done?
Chair Rosenbaum, you're absolutely correct.
Okay.
Yes.
Any questions?
Chair, I move to approve the renewal of the 16 agent agreements listed in the February commission materials.
Commissioner Kern.
Yes.
Commissioner Floyd.
Yes.
Commissioner Harper.
Yes.
Commissioner Molinas.
Yes.
Commissioner Pasick.
Yes.
Commissioner Reval.
Yes.
Chair Rosenbaum.
Yes. Let's do the second one too, Brian.
Thank you very much. Under your second tab, you have a permanent appointment for, under 471752, spouse child. This comes as a result of resignation, disability from the agent, Sidney Bauer. He is here with us today. Underneath there, you'll see the application. Britt Bauer's been running this store really more than the last year of this temporary appointment, 15 plus alongside her father and mother. Since that time, you'll see a small overview of what they've already done to the business, made some significant strides in terms of the operation. Hopefully, very soon there's some space available. This isn't a compact complex. We're encouraging the Bauer family to move forward with additional space. I think Britt's tasked with this challenge. If you ever need the specialty tequila in Oregon, you go to Britt because that's the kind of portfolio she serves. So I'd be happy to answer any questions. but all over in attendance.
Would Britt please stand up? So
I told you he would do it.
Is Sydney here? I just like to stand up and thank you.
I knew you guys would have fun with this.
Oh, yeah.
Yeah. So
I'd
I'll
like
go
to
ahead.
know who we're dealing with.
Yeah.
Good luck to you. Congratulations. Let's take a roll call.
Chair, I move.
Oh, you want to support?
Move to appoint
Oh.
Britt Bauer as the permanent agent of store 1237 Beaverton Allen Boulevard, effective February 21st, 2020.
Commissioner Kern.
Yes.
Commissioner Floyd.
Yes.
Commissioner Harper.
Yes.
Commissioner Molinas.
Yes.
Commissioner Pasek.
Yes.
Commissioner Revel.
Yes.
Chair Rosenbaum.
Yes. We're going to take a 10-minute.
Could we take a photo right quick?
If I may, Mr. Chairman, I have one opportunity left to embarrass Mr. Bauer, who's leaving. I have prepared a plaque. If we could ask him to come up and take a picture with the board.
Can I get behind him? I want to stand behind him. Cast that shadow over his head.
And then you could have a break and thank you
No,
so
that's
much.
all right. I did that. Please.
We're up in here. And if you guys just stand behind. That'd be great. That's your father's in the middle, because he's the one who earned it.
All right.
Yeah, we in?
Good. 1, 2, 3. Couple. We got it. Thank you. One more.
Okay. Let's go do it.
Okay,
We're ready.
we'll give.
We're refreshed and we're ready.
Good. Thanks, Chair Rosenbaum, Commissioners. We'll give Laura just a second. The first one will be a presentation. On the back of you, there's also some hard copies that have been produced for the first one. Under your first tab, this is as a result of a resignation from Agent John Biber. The store is in the north end of Bend. This is the one store left in Bend that is looking for rejuvenation, refreshment, if you will. As you know, we added 3 stores in Bend. Commissioner Paulsack lives there. He's been to several of them, but I think hopefully what you'll see today.
Makes it sound like I'm hanging out there. I'm sorry.
Well, you visited with me, so
that is true. That is true.
So, again, a result of agent resignation, we had extreme interest. This is a market that everybody wants to be in. Approximately 35, 40 interested.
No kidding.
15 plus that we met with. What you're going to see today is 5 applicants for the reinvigoration of Bend North location. So with that, first on the docket is, and I might mention this store is in decline. Every applicant that is here today is well aware of it. We've been extremely upfront through this process. But the competitive nature says they know what Ben's doing, and this store has the opportunity to grow. Thank you very much. Allison, did you leave? Oh, there she is. I will mention to all of the applicants today, state your name for the record, 1, and number 2, you'll have 5 to 7 minutes, and we do have a timer in the far left of the dais.
Oh, you'll follow that.
Yeah.
Thank you kindly.
Thank you very much.
I'll give him 7.
He's a tough one.
Oh my gosh, you thought you looked familiar. Now I am a regular at the.
So just for transparency purposes, I'm going to give you 7. Not 7.5, just 7.
Thank you.
And he will shut you off, and then stop.
Commissioner Rota.
Oh man, I'm telling you, the worlds are colliding now. You know.
Is this the liquor store on in that community?
It's on the north side.
If you have
So it's not. Was it not?
Okay.
Circle
back.
It's right on the stretch, right?
It's not. It's not a.
Can you hand me
It's
an
not a
extra
community with a bunch of condos
You got an
around
extra?
it.
No.
Perfect. Thank you. Let's roll.
Although by this afternoon there could be condos popping up in Bend.
Ready?
Sorry.
Ready? Go.
Good afternoon, Commissioners, and thank you for having us here today. My name is Allison Kogan. I'm here with my husband, Drew, who will be helping to run the store when I'm appointed agent of the Bend North Liquor Store. 3 years ago, we were given the opportunity to take our love for working with people and apply that to building relationships with our customers when I was appointed as agent of the Bend South Liquor Store. We have won awards at agent training 2 years in a row for top sales growth and work hard to meet the needs of our customers.
We have a passion for retail and believe that being present as the owner-operators helps to set the tone for the culture of our store and to build trust amongst our customers. We have a quick video we'd like to show you that highlights what we have done at Ben South, as we believe it is indicative of what we can also do for the Ben North Liquor Store. In the time that we have owned Ben South, we've doubled sales by building a strong customer base and store environment that is welcoming and makes people want to return. Our vision is to provide convenience and variety to meet the needs of Ben's growing community through friendly and knowledgeable staff and an enjoyable shopping experience. Customers know they will receive excellent care and will discover new items they may not have noticed before. Visitors to town can find local spirits and gifts, and locals make it their regular store because our store feels like home to them.
The Ben North Liquor Store currently has sales of approximately $4.5 million, with 82% of that being lobby face-to-face sales. It has a loyal customer base that we want to build on. In the last year and a half, 2 expansion stores opened on either side of Ben North, which have caused a 28% decrease in store sales. We believe our plan will turn this around and lead to a renewed increase in sales.
We will rebrand Ben North Liquor Store as Ben North Bottle Shop, a one-stop boutique shop for all of your liquor, beer, wine, tobacco, mixers, and gift item needs. This will begin to set the tone for the changes in store for Ben North, and will set it apart from its surrounding competition. Ben North is centrally located with great access in and out. We believe the current store has outgrown its space, but would like to stay within the shopping center. We have the same landlord at Ben South, and in the back of your booklet, we have included information on 2 locations within the shopping center, as well as a letter from the landlord stating that they are committed to working with us to determine a new, larger location. In the meantime, we plan to make the following changes to the current space that we believe will help to recapture customers who have left and grow sales through a unique shopping experience that shares our vision for the store.
We plan to change the space from the outside in. The current exterior sign will be replaced with a more visible version. We also plan to update the exterior lighting, move the ice machine, put up decorative window frosting, and add natural wood siding, which will transform the entrance to our store as well as make it more visible from Third Street.
The current interior of the store is disproportionate, with the stockroom taking up 2/3 of the space. We will reorganize the stockroom so it is more efficient for receiving freight and stocking bottles, allowing us to gain more retail space. We will push the dividing wall on the retail side back approximately 12 feet, adding 288 square feet of retail space.
In the current space, there is a wooden ceiling that we plan to uncover by removing the partial drop ceiling. This will make the space feel larger and brighter. Additionally, we will replace the flooring, shelving, add a fresh coat of paint, and convert the lighting to brighter, energy-efficient LEDs with auto lights over the register. We also plan to update the checkout counter for a more modern look and feel.
The layout of the current sales floor is crowded and does not flow well. Pushing the center dividing wall 12 feet will create more retail space for a greater variety of spirits and will allow for the addition of beer and wine. We will rearrange the placement of spirits along the perimeter and island shelving for better visibility and in a way that highlights each category and encourages upselling.
We will review the current inventory and replace products that have a low turnover rate. We will listen to our customers and have feedback cards where they can put in requests to help inform variety and selection. We will also schedule tastings to introduce new products to our customers. The changes we make will help to establish Ben North as a one-stop shop, and will encourage customers to stay longer and buy more.
Ben North Liquor Store currently does 18% of its total sales to licensees. We plan to grow this percentage by working with a longtime manager to build relationships with existing accounts, as well as actively pursue new accounts. We will use what we've done at Bend South and build out a website that allows our licensees to conveniently order online, and will offer a flexible delivery schedule and fintech payments as an additional service. All of these changes will help to accomplish our vision of creating a unique and thriving outlet for liquor sales on the north end of Bend. By adding a wider selection of spirits and related items, as well as beer and wine, we anticipate the sales will grow exponentially as customers stay longer and find more items to purchase. Additionally, we believe that updating and modernizing the space before we move to a larger location will draw in customers who are going elsewhere and allow us to build relationships with the current customer base.
We value the dedication of the current staff at Bend North.
1 minute.
And plan to retain all employees on a 30-day probationary period. In the procedure booklet, we've outlined our control plan, 2 proposed new locations, our social media and marketing plan, our timeline upon appointment, and our projected budget.
Thank you for the opportunity to present to you today. We love this business and hope you are given the chance to help Bend North grow and thrive.
28 seconds left.
Wait a minute. They yield back. Here we go.
Chair.
Commissioner.
As you're aware, this has been a decline in the store. I didn't see any demographics of what in here, and you're talking about the possibility of growth.
So in the back of your booklet, I included information on the transportation. Traffic counts for the Wagner Mall on page 26. This store has been greatly impacted by 2 expansion stores that went in on either side of it. But the location itself in that shopping center is one of the highest traffic locations in Bend. So 22,000 cars a day at one of the entrances.
I saw that.
Yeah.
Do you know what the proposed development of housing, the demographics of the age group?
There's a fairly large housing community behind the shopping center, which is mostly residential, but it is located in a very high traffic business corridor. So there would be not a lot of demographic information on people actually living in that area. It's centrally located right in the middle of Bend, basically. It's called North Bend, or Bend North, but it's because of when it was originally placed there. It's now mostly midtown. So it's a high traffic business corridor that it's located in, and it's almost a full square block.
Thank you.
Probably better access than most of the stores in the city. So access in and out is great, and it's just
It has 6 points for the entrance.
Okay.
Hey, Chair. So where do you live in regards to the current location you have? So what's the time from where you live to the new store versus the old
Great
store?
question. We actually live closer to Bend North. We have the South Store now, which is about a 10-minute drive from our house, but we live in northwest Bend. So just above where the Bend North Store is, we're about 5 minutes from the Bend North Store.
Thank you.
And the 2
Thank you.
stores are about 4.5 miles apart from each other. With traffic, it takes about 10 minutes.
I was gonna make a joke about the traffic, but I won't. You're
Former
40,
Highway
40 minutes
97.
from everywhere, in Bend. I'm just kidding.
It used to be when we first.
Yes.
Any other questions? I have one. What's the thing that keeps you up at night in terms of operation of your present store?
Staffing.
So, how will that change with the new store?
We're partnering, and I'm committed to being there as much as I can, and I always am. I have a great team at my current store, a great manager, and we're in contact all the time, even if I'm not there. But I wouldn't have applied if I didn't think that I could do the best job that I could do. I work hard, and we're both committed to making this a successful business.
So what is it about staffing in the store that keeps you up?
It's one of those variables that you can't control. So I try hard to find good people and to treat them well. We just added health insurance for our manager and to do things that make people want to stay. But Bend in particular is a really hard place for hourly employees. So I believe of the liquor stores in Bend, we start our hourly pay higher than most other stores, but there's definitely a retention issue. With both of us working though, we're able to cover when coverage is needed, and I would never leave my staff hanging out to dry.
We plan to have a manager at each of the stores, and we're also available and close by, so plan to be actively involved in both businesses.
Any other questions? Thank you.
Okay, thank you. With that said, we'll move immediately into the next applicant. This is Central Oregon Spirits, Robert Dickey.
Actually really changed. Look like it.
Sure. You're done. For the record.
No problem.
Some people like.
If there's extra.
She really wants.
I would be
Well, I need
surprised if they didn't bring it up for all of
Thank
us.
you.
Thank you.
Thank you.
Chair and Commissioners, in this regard, when they are not required to print hard copies if they are displaying, because we need three. One is for the DM, the record for administration, and one record. That's all we're trying to be a paper friendly, if you will.
Okay.
However, we don't. Oftentimes, you do get a hard
Once
copy.
you start giving them out, there
Forget
better be
it.
enough for everybody.
Yes.
FCC violations.
Wow.
You're on.
Chair Rosenbaum, Commissioners, thank you for this opportunity to be considered as the new agents of Bend North Liquor Store. I'd also like to thank my wife Lori, partner and co-worker of 45 years. As you can see, we are Central Oregon Spirits and Tobacco. I would like to share a little history with you. I presented for this store over 10 years ago. Not being appointed, I went to work for John Biber, the appointed agent. Less than a year later, I was appointed as the temporary agent of the North Bend store at the request of Brian Fleming. Lori and I arrived in the North Bend in less than 48 hours and began operating the store. After permanent appointment, we moved the store and remodeled in 60 days. Remove and remodel was a total rebuild. New KNDS computer system, new sales counter, new flooring, ceiling, lighting, and new store shelving. The store doubled in size and converted to non-exclusive, adding beer and wine. The move, remodel, and conversion generated an annual sales increase from 1.8 million to 2.5 million in just under 6 years. On to Prineville. I was appointed Prineville agent in January 2014, while Lori was appointed North Bend agent May 2014. We continued to work side by side, traveling to and from both stores. We expanded and converted Prineville in fall of 2014. Prineville increased in size by 33%, adding 9 cooler doors for beer and wine. Between 2014 and 2019, annual sales increased by 43%, from 2.1 million to 3.1 million. Moving on to Bend North. Pictured here is Bend North, as it has been for over 45 years. Our vision of the Bend North store will begin at the front door by rebranding the storefront. New logo, new LED sign, outside decorations, and window banners. I believe leaving the Bend North store at or near its current location will play a critical role in the objective of increasing sales, restoring customer confidence, and preserving the community history that the store has been a part of for the past 45 years. Moving into the interior of the store, we will purchase a new register system, new shelving, a time lock drop safe, and install security measures for safety and security of all customers. Part 2 of the action plan is to increase the sales area by moving the back wall 18 feet into the stockroom, creating new, much-needed floor space and additional shelving. Continuing the action plan, 15 to 28 days, we will add new equipment, fixtures, ice merchandiser, cigar humidor, new sales counter, fresh modern wall colors, creative decorations, and of course, new category signs. Our final action plan is to reset and organize the stockroom, creating a new office and employee area. Financial projections. Our investment will be more than monetary. It will include attention to detail, time, energy, and a passion to excel with the desire to succeed. Future expansion. 2 options. Option 1, possibly expanding into the space next door, a restaurant. Option 2, a new space may come available as the landlord designs and remodels existing suites within the mall with street access. Both options are 2 to 3 years in the future. Our vision of the Bend North Liquor Store is balance, clarity, and prosperity for all parties involved, from the customers to the licensees, the vendors, owners, and OLCC. We will achieve this through branding Bend North Liquor as a clean, inviting, one-stop shoppable store, offering superior customer service with a well-trained, knowledgeable staff, building a strong relationship with licensees and other OLCC agents, developing a modern website that is user-friendly as well as social media presence to target new age shoppers. The store may not be amongst the largest or the top producers at this time, but we will offer the best service, the best product selection possible, and a new wonderful shopping experience from this day forward. Thank you for your time and consideration. If you have any questions, we're here.
1:20, you got time.
Well done. Well done.
I'm old school, 5 minutes.
I have a question, Chair.
Commissioner?
Thank you. Brian, so the applicants each have a liquor store now, if I understand you correctly. Can you tell me where their current liquor stores are at?
Chair, Commissioner Harper. So in the back of the materials, it shows the store, current operator. So Lori and Bob Dickey are in Primeville, Oregon. Allison, who you had just seen, is in the South Bend area. If appointed, they would both continue to operate their existing stores. The next 2 applicants are also liquor agents, and so those 2 are willing to forego they would resign from their existing locations and move to Bend. These 2 folks. Oh, go ahead.
So Primeville. So we have Primeville. So what's the time distance from where you live? And I'm assuming you live in Primeville. So where do you live in comparison to this new store that you're applying for? So we have a 10-minute. I'm trying to get some timing up in my head here.
We have our main family home is in Bend.
Oh.
It's a home that we've owned since 1979. We also have a very small home in Primeville, so we are able to be at both locations. We purchased a little home, so we didn't have to drive in the evening or early in the morning. So from Primeville to Bend is about 42 minutes.
Okay.
With no traffic, which is very nice. From our Bend home to the Bend North store, we are approximately 3 to 5 minutes when we use the back street.
Wow. Okay, and you only have 1 store amongst the 2.
Correct. We sold Lori's store North Bend on the coast in the first of 2018.
All right, yeah, okay, I remember. Okay, I was getting the North Bends mixed up because that's something weird, unique is a North Bend chair, and then there's North Bend.
Bend North.
Bend North.
North Bend and Bend North.
It's confusing, but it's 10 minutes from where your Bend house is, right?
Call it Farewell Bend. Less than 5.
But less than 5. Okay.
Yes, we've been residents in the north end of town since 1979. We've lived very, very close in that part of the community.
All right. And we heard earlier that staffing could be a scenario. Do you foresee a staff problem?
A minor problem. We own the business, and we had a very large group of people that work for us. They still work for us from time to time. So there's a wonderful pool of people, as well as our connections with the vendors, the bars, the restaurants, the suppliers. We have a great rapport with them, and there will be a little bit of a struggle, but nothing significant.
Any other questions? I know that Brian looks at this thing, but I'm looking at your financial projections, including the 30,000 in contingency or working reserves. You've got 300,000.
Yes, sir.
Then I'm looking at your source of funds. It's really close. Would you tell me? I'm a little concerned about that. Not much. I'm waiting for you to give me an answer so that my concern goes away.
My projections of the finances and the purchase of these products are very true to nature. From bids from the various vendors. I do have some of the material from coolers to shelving already available in my possession. I believe that these dollars are very accurate, and I'm confident I will be successful with these dollars. If not, I do have additional funding and sources to.
That's not on here?
No, sir. I only projected just a little bit over of what was requested of me from the information packet.
Okay, because you know, I'm looking at this. I'm a numbers guy, and this is close.
Yes, sir.
And the other question, just for my edification, I'm assuming that the Bend Campgrounds with a K is just there's no spirits. There's beer and wine in there, or what? What is it? It's just
no longer exists.
No longer exists. The Bend Campground.
It no longer exists?
The family operated from 1977 until 2005.
Okay.
The sign was there.
The
sign was there for a while. I remember. Is it? Yeah.
It was a KOA campground, convenience store that we built, gas station that the family built, a full service operation on that very, very north end of Bend back in the day.
Okay. Thank you.
Thank you. With that, we'll go move on to Joe Fierstein. Joseph.
Thank you.
Thank you.
Thank you much.
I think this.
Oops.
I think that's yours.
Oh.
Take it with it. It's a pretty small store.
It is.
It is.
Thanks, Joe.
It is a lot of value for a small. This whole area is
ready to roll.
A lot of attention. A lot. So it's the last area that's what I'm up. So try to be all shopping mall. It's coming.
Thank you, Chairman and Commissioners, for the opportunity to present my proposal for the North Bend Liquor Store. My name is Joe Firestein. I'm the current owner and agent of Eastport Liquor Store, agency 1186. A little about my history. I've grown up in the back room of a liquor store since I was the age of 11. I became temporary agent in 2012, being at the age of 24, when my father, John Firestein, suddenly passed away from a heart attack. I decided to step in and run the family business. My father was an agent for 15 years. Being in retail his whole life and the passion for the industry, it was his dream to own a liquor store in the state. As I grew up, I became more involved, unloading liquor trucks after school, stocking shelves, catching thieves, being a helpful hand around the holidays. More importantly, learning my father's dedication and hard work ethic, not realizing at the time while working 6 days a week was necessary. Since my father's passing, knowing how big of shoes I had to fill, I took Eastport Liquor and turned it inside out, managing 8 employees, learning everything I could as fast as I could, from customer service, daily deposits, daily sales, control sheets, audits, and much more. Starting with increasing the floor space and having 80 square feet of liquor shelving, making for an all-around better customer experience. There's one thing I could say I've found successful, it would be the value of customer satisfaction. Making the customer feel at home and want to come back. Greeting them as they walk in the door, helping them with their selection, taking it out to their car for them. Becoming a part of the community as a whole made a big impact on my success. Even being recognized for turning away VIPs and minors, as I've had customers thank me for making it a safer, more appetizing environment in the store. More recently, in 2017, I had moved to Eastport Liquor Store, 10 blocks north to the corner of 82nd and Powell. Having over 1,200 square feet, hundreds of new SKUs, and becoming non-exclusive, bringing in beer and wine, which has been received very well by the community, even though we are next to Winco. Taking the knowledge I have learned over the past 7 years of becoming an agent, and recently purchasing a house in Redmond, just 14 miles outside of Bend, I would love the opportunity to get North Bend back to where it once was. Presently, North Bend needs immediate renovation. With my prior knowledge of a similar sized store in Portland, I'm more than confident I have what it takes to turn this store around. Currently, Bend is just about 95,000 residents, 100,000 residents living in a 5-mile square radius. Along with the store's proximity to Highway 97, who sees 20,000 vehicles a day, it is crucial for this store to tap into that resource. With proper advertising, social media publication, updated store signage, proper employee training, I'm confident in the fact I can get this store back to where it once was and beyond. Walking into North Bend for the past couple weeks, I would currently say the store is not customer friendly. Being outdated, tight on space, low in lighting, along with the fact 2 brand new liquor stores within a 3-mile radius, customers simply want a modern day option in the area. Within the first 30 days, I reorganized the stock room, taking down the current shelving and adding numerical tonnage lines. In turn, pushing the wall back 10 feet, back wall of the sales floor, that is. Giving the store much needed premium liquor shelving. Adding a minimum of 64 feet of shelving on the sales floor, very similar to what I've accomplished in my father's store. Over the past couple weeks, I've reached out and been in contact with NAI Elliott as well as Compass Commercial Realty. We have found a 4,900 square foot available space directly across from the store's current location. I also feel confident in the fact that this store needs to go non-exclusive, bringing in beer, wine, lottery, cigarettes, and tobacco, all of which the store does not currently have. Giving the store and state included a much bigger profit altogether. Since taking over my father's store, I never imagined I would follow in his footsteps and have his passion for the industry the way I have. Making customer satisfaction my #1 goal, I'm definitely not shy on putting in the hours necessary to get North Bend back on track. Thank you.
Very good. Any questions? Well, I got one. Brian, it's to you. Let's say we give this store, that means you're going to sell the other store. So tell me the time frame, just so that I understand it. Not so much for this, but in general. You move to the other store, how long does it take to get rid of the store in on Powell?
Chair Rosenbaum, the store that he currently has on 82nd would resign effective immediately, and then we have a 120-day calendar that we use. So in the event any of the ones that would resign, we'd immediately begin to get a assessment of the store. So we could be anywhere around 60 to 90 days. We use 120 as a buffer for the full resignation, an audit of the store, fixtures and equipment, all of those types of things.
I understand that. My question is, will both stores be operating continuously?
Absolutely.
And how does that work? You stay at that store until it's sold?
I won't answer for Joe, but it's expected that Joe has to take a day off. He probably has a manager on site already that for his day off. I would guess that of any of the applicants. They all have people that would continuously operate the store. And as you know, technology, whether it's video or the point of sale machines, they can view that from pretty much anywhere.
I just wanted to know that both stores will be up
Absolutely.
and with revenue during both that period of time.
Yeah, in the we would not allow an agent to close a store and discontinue the revenue any location in Oregon, unless it was for a day or two for a remodel. We allow those when you have to move one to another and or pull up all the shelves. But we do allow closing for a day or two max, and that does happen just because of construction renovation.
That didn't come up before, so it's good to know.
Great. That's a great question.
I have one question. Did you say that you currently you purchased a home in Redmond?
Yes.
So you currently reside there now? So
yeah. I commute there on the weekend.
And you have managers overlooking your Eastport location? Okay, thank you.
Mr. Chair, just a question. The business plan for moving store, as it's written here, is this your intent on this? Or is this an option that you have, an alternative that you're talking about?
Oh, just an option.
Okay.
I wanted to know the options.
Nope, just wanted to know that. Great, thanks.
Chair Rosenbaum, Commissioners, just as more of informational, as any store proposed and move comes with conditions. We'll go to the site location, evaluate the location. We have to post it for 14 days. We got to hear from the community. Are you okay with this? It's not often that we get a contentious when the liquor store's been operating in this area for, you heard, 45 years. But definitely has to be posted, decided upon whether there's huge public outcry. You generally don't see them here because there isn't. And if not, Director Marks always receives the opposition. Sometimes it's just communities that don't want it to move a half a block or things like that.
And that goes for national chains as well.
Yeah,
that's correct.
If I put my weight behind a 9-iron, I think I could reach it. I mean, where he's talking about. So it's not. I get it. It's in that area. I just didn't know what the intent was there. If it was just an alternative that you were just exploring. Okay.
We have, Commissioner Palcic, we have been very upfront with every applicant here today, all five, whether it moves or not. We've told them it is a very narrow area. We have a brand new store to the north at Robal Plaza.
Correct.
We have a brand new store at 3rd Street. Yep. And the community that lives behind there, they're used to the store being in their community. So we're not moving this thing very far, if at all.
Yep.
Thank you.
Sure. I'd just like to share that. Are you going to get used to that new lifestyle in Redmond? Because you're leaving Southeast Portland, baby. Okay, because you're going to get a number of years added to your life. That's a good thing. You might get a little hair. Yeah. You might get it in bed, baby.
He said it, not me.
All right. Thank you so much.
Congratulations. Yeah.
We have just two more to go. Ryan Green at Green Spirits. This particular applicant also would resign at the current store he's operating in Eugene in the event of appointment. Just so you know.
It's a
lifestyle.
Desirable
Are
place.
you kidding? It's the place to be. I don't know what's wrong with all of you. I mean, it's the honest to goodness.
It's 4 hours from the ocean.
Yeah. All right.
You just wait until something big happens. We might be the coastal line. Who knows?
Thank you.
Oh. Well, we're looking. Yeah, right.
Thank you.
extra. Okay, state the name for the record. And
Okay.
Thank you, Commissioners, for the opportunity to present today. I'm Ryan Green. I'm the agent at Springfield East. A little bit about myself. I have a marketing degree from the University of Oregon and a culinary arts degree from Western Culinary. I've been with the OCC for about 14 years now as a cashier, manager, and agent at Redmond, Portland Center, and Springfield East. I assisted in the relocation of the Redmond store to a larger location. At Portland Center, we remodeled, updated, and increased sales 25% from 2009 to 2012. At Springfield East, we also remodeled, updated, and increased sales 59% from 2012 to today. I pride myself on product knowledge, exceptional customer service, and most importantly, hard work. I'm extremely excited about the Ben North store. I met my wife while working at the Redmond store. She's born and raised in Central Oregon, and we have lots of family in the area. We'd love to spend more time with her. Current status of the store. Ben North has been hurt by expansion and is in need of improvement and modernization. Divided my plan to improve the store into 2 stages. Here's stage 1. To a plan, I would push the wall dividing the sales floor and the warehouse back 12 feet to increase the sales floor by 300 square feet. Next, I would convert the store to non-exclusive and carry beer, wine, and cider to create a one-stop beverage store. I'll move the outside ice cooler, soda coolers, and new beer coolers to the back wall to expose the front windows and let natural light in. I'll remodel the front counter with 15 wood and retro pendant lighting. I'll paint the walls sage green. I'll add tobacco to the product mix. I'll add a small third gondola to the sales floor. I'll replace all 4 computers and update the PMDS system. I'll purchase a delivery van to better service the licensees. I'll remove the drop-down ceiling over the sales floor to reveal the 10-meter wood ceiling to make the space appear larger and more lighting. I'll install vinyl plank flooring over the old linoleum floor. I'll replace the wood shelving with larger copper vein. I'll refurbish the exterior sign and add additional signage behind and on the south side of the building. I'll add 3M security film to the exterior windows and update the security system. My plan is to retain all the employees and hopefully the manager too, and we'll evaluate the situation after 30 days. I'll also purchase logo color shirts for the staff for a professional look. On to the pictures. The first picture shows before and after drawings of the larger sales floor. Second picture shows the exposed front windows, increased shelving, and a new cooler location. Third one shows an alternate view of the sales floor and then the new warehouse layout. Next is the front counter, the pendant lighting, and then the vinyl plank floor. Last picture shows what the ceiling will look like with the drop-down ceiling unit. Stage 2 of my improvement plan, I'll work with the property owners to expand in the restaurant next door or to relocate next to Albertsons in the former Nature store. Doing so, I'll be able to increase the square footage to between 3,000 and 5,000 square feet. At that point, I'll add additional coolers. With the additional square footage, I'll be able to significantly increase the selection of liquor, beer, wine, cider, mixers, and tobacco. I'll install a dedicated tasting station. I'll purchase a cigar humidor and a walking display case for high-priced items. That's my plan to significantly improve Ben North. Some additional thoughts. If appointed, I will resign from Springfield East and devote 100% of my time and effort to the Ben North product. I feel that I of increasing sales of struggling stores to succeed in the pandemic. Thanks again for the opportunity. I really appreciate it. I'm happy to answer questions.
You guys are getting way too good at this.
Well done.
Any questions? I have one. And I'm looking at remove the drop-down ceiling to reveal the tongue and groove wood ceiling. This will make the space feel much larger and inviting. Right now in the store, is there a spot where you could see that? Or
yeah,
did
the
you?
last picture.
Yeah, no, I got it. I got this here, but is this the actual?
That's the actual store.
No, I know it's the actual store, but this is a picture of what you would do with the drop-down ceiling, where you would take everything out, right?
Correct.
And is this throughout the whole store, or just in this area?
Through the whole store.
I know you're going to do it throughout the whole store, but
The drop-down ceiling is
Yeah.
over the sales floor.
Okay.
And then it stops as it goes into the warehouse.
yeah, I was impressed with that. There's almost a $300,000 difference so far in the prices for looking at remodeling. So it's really kind of interesting in what people are looking at in terms of what they can do with this. Thank you. I appreciate it.
Okay, and the last applicant today is Christine Milstead. She is new, presenting to the board and does not have a current store.
Thank you kindly. Yeah.
Thank you. Thank you.
Thank you very much.
Thank you.
Okay, you have an extra. Okay, just remember to state your name for the record.
Good afternoon, Commissioners and Chair Rosenbaum. My name is Christine Milstead. Thank you for this opportunity to share my plan with you this morning. I'm currently a territory manager with Young's Market Company. I've been in this position for now 3 years. I've enjoyed the transition from retail into the wholesale side of the industry. I use my relationships in both on and off-premise accounts to accomplish my goals, using marketing, servicing, and merchandising as my main focus. Prior to Young's Market, I was the store manager at East End Liquor Store for 10 of the 14 years I was employed there. During that time, I learned the foundation of running and growing a successful liquor store. We received outstanding evaluations year after year. After relocating, 3 store remodels, and converting from exclusive to non-exclusive, our store's revenue reached well over $11 million. My leadership, ideas, and concepts helped lead the store to what it is today. With my passion and experience for this industry, I am excited for this opportunity. This is what I love to do, and I would love to get back into my retail leadership roots. The North Bend Liquor Store has been part of our community since 1974. Part of my vision is to remind our community of its longevity. At this time, I would remain in its current location. It's well established with regular shoppers. It's in a busy shopping center with ample parking. There's high visibility and traffic from 3rd Street and Revere Avenue, with a highly populated neighborhood directly behind it. There is also a very busy industrial area near that employs some of our consumer base. This building will be undergoing both interior and exterior upgrades, with future opportunity to expand into the adjoining restaurant. In the meantime, I will be actively searching for a larger location within the geographical boundaries. The impact the expansion stores has had on North Bend Liquor Store has been significant. Last year's fiscal sales were $4.5 million. Prior to the expansion, they were growing at around 19% on average. Now this store is experiencing a 20+% loss month after month. The average progression for loss is within the first 2 years of opening a new store. This December will mark 2 years. I am confident with a complete remodel and rebranding, as well as converting to non-exclusive store model, with myself and my team executing a unique and positive shopping experience, we will quickly reverse these losses into gains, well before that 2-year mark. My vision for the remodel starts with rebranding. Wagner Mall Liquor, Beer and Wine. We will add almost 600 square feet into the existing sales floor, making it 1,330 square feet. This will give our guests an open and clean, comfortable shopping experience. It would allow for an expanded spirit selection and the ability to convert into a non-exclusive store model, adding beer, wine, hard cider, and tobacco, making us a one-stop beverage shop. I am committed to replacing the interior and exterior paint, replacing the tile floors to stained concrete, new wall shelves and middle gondolas, new LED lighting for a bright, comfortable shopping experience, removing the ceiling tiles to expose that beautiful wood that's behind it, new counters, new window tintings and coverings, custom category signs to go along with the barrel and name. I've designed a new logo for the exterior sign. I will install an overhanging awning for ambiance. I will also replace the software and computer hardware, including security systems and locks. With all these changes, we will spread the word using all the outlets allowed by the OLCC, including social media, store website and blog, local papers, Google, and radio. Now, none of this can happen without a strong team. Over the last 2.5 years, I've built a great relationship with Monica, the store manager, and the other team members at North Bend Liquor Store. I've expressed my interest and plans with each of them individually, and they are excited for the change and are committed to moving forward with me at Wagner Mall Beer and Wine. Guest service is the forefront for any successful retail environment. Making our guests feel welcome and appreciated as valued customers, they will be repeat customers. I will focus on licensee accounts, retaining them and adding new ones. I'm sorry, I messed up on that one.
It's okay.
As I have in the past, I will continue with regular training on how to spot visibly intoxicated persons and keeping alcohol out of the hands of minors, and how to handle these situations as they occur. As a mother and an active member in our community, I understand the importance of keeping minors and our streets safe. I believe in staying educated, not only in the products that we sell, but also in guest service, theft deterrent, and safety as well. I am a certified specialist of spirits and will continue to learn and educate myself and my team to new upcoming trends and marketing strategies. I want to include that I have built excellent relationships with the existing agents and store managers in our community. I have great relationships with licensee accounts, and I plan on using these relationships as an asset for our success. My current employers are extremely supportive for this opportunity. They are aware of the timeline and are ready to work with me again on the retail side. I am extremely passionate about this opportunity and will use my experience to reverse the store from the path we're following. I am a team leader who leads by example. I have a great team who has expressed the desire to share my vision. I know Wagner Mall Liquor, Beer and Wine will have great success. I am ready to focus my time and energy as a full-time liquor agent. I hope you will allow me this opportunity. I appreciate you, your time, and your consideration. Thank you.
So I got a real quick question to ask. This is your team, right?
Yes.
Every single person here has made a commitment to you to come to the new store?
They have.
And
they are currently employed there.
Oh, okay. Okay. Got it.
Chair.
Yeah.
I have a question. So Mark Merrick is the current agent at the East Bend Liquor Store, correct? Who is he to you? What relationship do you have with Mark? He's just a friend, and he's your sole. It looks like your sole financial backer.
He's helping with that as well as my refinancing.
Okay.
Commissioner Floyd, in order to come to you, you have to have availability of asset, and because of the timeline and approvals and whoever, we did not have that, and so she seeked out somebody to help her, and that's what has happened here.
Well, he's got a lot of confidence in you, yeah? Okay.
Okay.
Any other questions?
Sure. None for you. I'm kind of getting to be the old guy on the council. 5 years ago, Rob Patrick and I had a meeting with Steve Marks and the liquor industry in Florida. And at that time, 2 large grocery operations in Portland had secured $1 million from the industry to privatize liquor in Oregon. I say that because we often hear about how the expansion has caused this store or that store to decline. The industry told us point blank that if we didn't expand what we were doing from 1939, they would make sure there was more than $1 million in that kitty to privatize liquor in Oregon. By the time we arrived home, they had contacted those 2 large grocery outlets and says, give us back the $1 million. We have a deal. The deal is we will help provide Oregon with demographic information on everything that we can give them, and they will open up their market. One of the things that we're seeing now is, and all of you have presented this, and I say this for those in the audience who wants to get into this industry, we've given established organizations multiple opportunities to improve, in my opinion, what they were doing and creating a purchasing opportunity that was beneficial both to them and to their community, so that women would feel confident and comfortable going inside a liquor store, which they didn't. This is where we are today. So from my perspective, when I hear that an existing organization has suffered 20% losses, and all of you presented fabulous remodeling ideas on how to make it a good shopping experience, I think we did the right thing. And we're still not privatized. So I want to say thank you, and please keep it up.
That's an excellent point.
Commissioner Revol, duly noted, and he's been a part for a long time here. The system has got better. As a result of your appointments, the applicants, the pool gets better and better every day.
Well, the commissioners get better and better every day.
I agree wholeheartedly.
The commissioners will now go into executive session to deliberate on the agent selection pursuant to the authority of ORS 192.660 sub 2 sub A. If there are members of the media present, representatives of the news media and designated staff shall be allowed to attend the executive session. Representatives of the media are specifically directed not to report on any of the deliberations during the executive session except to state the general subject of the session as previously announced. No decisions may be made in the executive session. We will return to open session in this room. We're back in session. Who's got the
chair?
Before you do that, Commissioner, one quick question. We get paid the big bucks to sit on this commission. And it happens every time. There was absolutely no bad candidate. Nobody we didn't think could do the job. It's really tough. And Commissioner?
I move to appoint Christine Milstead as the permanent agent of store number 1163 Bend North, effective March 2020.
Commissioner Curran?
Yes.
Commissioner Floyd?
Yes.
Commissioner Harper?
Yes. What?
Me. Yeah, I've never done this in the period I've been here, but I'm gonna say no.
Commissioner Molinas?
Yep.
Commissioner Palsek?
Yes.
Commissioner Revol?
Yes.
Chair Rosenbaum?
Yes. Congratulations.
What are we doing next?
And can I share something?
Sure.
Where's Christine at? I pride myself in the support I receive from my current agents and the job they've done historically for the state. And I challenged myself because this class of applicants was phenomenal. And, it's to the point where we want to give people an opportunity. So I challenge you to do great, because you got some classmates that'll say, yeah, I don't want to hear them say I told you so. Okay? All right. Thank you, Chair.
That was very appropriate.
Chair Rosenbaum, if I may finish for the retail portion, you have the original invite. Agent training is coming up in April. You can certainly contact Laura. and or we can send another reminder. We're coming back to brown goods this year, public safety components. We have what we believe is already a pretty good show. We're talking prominent figures across the land. I would ask also that the new agent appointment is it required attendance, Chair Rosenbaum?
Yes, it is.
Okay, thank you.
Yeah, I'm good on the uptake.
Thank you.
We have exactly 3 minutes. So, acting director.
Acting director, that's a promotion. I like that.
It is.
Mr. Chairman, Commission, I'll give you 3 minutes out 3 minutes early. I don't think I really have anything to update you on today. The legislative session, as you know, is going on. It's very fluid. Things are up and things are down. So I can't even really report on anything solid because I really don't know. The biggest thing operationally going on right now, believe it or not, is we have started working with Nathan, our new hire, and I are working with our new managers or our managers across the agency to start building our next biennium budget. And we've put quite the comprehensive plan together to get more involvement from first-line managers all the way up to the director of the organization. That seems to be going well so far. So that's the biggest thing operationally going on at this point. But other than that, I don't think I have anything to report. Thanks.
Meeting adjourned. Thank you.